A very good afternoon, honorable dignitaries, esteemed guests, learned advocates, and all present today. On behalf of the organizing bodies, it is my privilege to welcome you to the workshop on legal rights and empowerment of persons with disabilities. This workshop has been thoughtfully curated by Mission Accessibility and jointly organized by the Office of the Goa State Commissioner for Persons with Disabilities, Goa State Legal Services Authority, the Department for Empowerment of Persons with Disabilities, and the Goa High Court Bar Association. Today, we bring together key stakeholders from the legal fraternity, policy-making institutions, and the disability rights community to engage in a meaningful dialogue on enhancing access to justice and institutional empowerment for persons with disabilities. To commence this program, may we please have the theme song of the National Legal Services Authority.
जाणीव न्यायाची सगळ्यां खातीर मळब न्यायाचे सगळ्यां खातीर आनंद न्यायाचो सगळ्यां खातीर विश्वास न्यायाचो सगळ्यां खातीर आमच्या ह्या भारत देशाचेर हक्क आमचोय बी आसा न्यायाच्या ह्या आसऱ्याचेर हक्क आमचोय बी आसा मुठभर मळबाचेर हक्क आमचोय बी आसा मुठभर मळबाचेर हक्क आमचोय बी आसा
अशें समजू नाकात दुखणें आमचें खंयच आयकचें ना आतां न्यायालय स्वता चावडे मेरेन येतलें
निराधारांक न्याय मेळटलो दुखेस्तांकय बी न्याय मेळटलो दिनदुबळ्यांकय बी न्याय मेळटलो चिंतल्यांकय बी न्याय मेळटलो आमच्या ह्या भारत देशाचेर हक्क आमचोय बी आसा उमेदीच्या ह्या फुलबागेचेर हक्क आमचोय बी आसा मुठभर मळबाचेर हक्क आमचोय बी आसा मुठभर मळबाचेर हक्क आमचोय बी आसा
गरीब आनी दुबळ्यांक फुकट तसोच घटमूट कायद्याचो पालव दिवपाक बांदील आसा विधिक्त सेवा प्राधिकरण नालसा न्याय सगळ्यां खातीर
To begin this meaningful afternoon, I welcome our distinguished dignitaries to the dais. I request the audience to kindly hold their applause until all names have been announced. May I request the following esteemed guests to kindly come forward and take their seats on stage. Honorable Justice Abhay S. Oak, retired judge of the Supreme Court of India. Honorable Justice Valmiki Menezes, judge at the High Court of Bombay at Goa. Advocate Rahul Bajaj, legal scholar and accessibility champion. Shri S. Govindraj, Commissioner for Persons with Disabilities, Government of India. And Shri Guru Prasad Pavaskar, State Commissioner for Persons with Disabilities, Government of Goa. It is an absolute honor to have all of you with us today. Thank you for being here. To formally extend our welcome and express our gratitude, we shall now present floral bouquets to our dignitaries. I request the following individuals to come forward and present the bouquets. I invite on stage Advocate Shivan Desai to present a bouquet to Honorable Justice Abhay Oak. I further invite on stage Honorable Principal District Judge Irshad Aga to present a bouquet to Honorable Justice Valmiki Menezes. I request Honorable D.P. Satwalekar to present a bouquet to Advocate Rahul Bajaj. I request Advocate Rama Rivankar to present a floral bouquet to Sri Guru Prasad Pavaskar. Thank you to all presenters, and once again, a warm welcome to our dignitaries. To formally open the session, I now invite Sri Guru Prasad Pavaskar, State Commissioner for Persons with Disabilities, Government of Goa, to deliver the welcome address and opening remarks.
Good afternoon to all. As part of International Purple Fest organized by Government of Goa, by the Office of the State Commissioner for Persons with Disabilities, jointly organized by the DPWD Government of India and United Nations, I extend a very, very warm welcome to our distinguished guest today, uh, Honorable Justice Shri Abhay Oak, Justice Valmiki Menezes. This conference is curated by Mission Accessibility team and extend a very, very warm welcome to my friend Advocate Rahul Bajaj and Advocate Amar Jain. We also have with us Deputy Commissioner CCPD Shri Ambastaji. We are expecting S. Govindraj Commissioner CCPD in a while. It gives me immense pleasure to welcome each one of you for this important gathering uh, organized with dedication and vision by Mission Accessibility team. I thank them wholeheartedly, not only for today's event, but for their ongoing national effort to make accessibility a lived reality, not just a legal right. The International Purple Fest is not an event. Everybody looks at it as an event, but we look at it as a movement which is now slowly spreading across the country. And we are very happy that some of the states are now coming forward to host similar Purple Fest in their own states. Maharashtra tried it on a very small scale at Pune recently. In fact, this idea was also picked up by Honorable President of India, and it was organized. Day Purple Fest was organized at the Rashtrapati Bhavan in Delhi also. So it gives a great pride to say that what we have started, initiated in the state of Goa, is slowly spreading across the country and across the Indian borders as well. We are privileged to have with us today Honorable Justice Oak and Honorable Justice Valmiki Menezes, who are here to address us in a while. Here in Goa, we have made progress, but as with many, eh, but as with many right bit movements, progress must never be mistaken for completion. The Rights of Persons with Disabilities Act, RPWD Act 2016, gives us a strong legal foundation. In Goa, we have leveraged this through initiatives that include accessible public transport. So we have introduced this accessible e-rickshaws, wherein a person on a wheelchair can move around in the state, go to his workplace. And this is introduced for the first time in the country. When we talk about giving employment opportunities, we have to connect the dots. And I think one of the most important dot is the transport facility that has to be accessible for persons with disabilities. And across the state, last year we introduced this wheelchair accessible e-rickshaws, where person now doesn't have to move from a wheelchair to the car and back to the wheelchair again. uh, Inclusive education schemes and accessible tourism infrastructure, this all has shaped with the belief that the accessibility is not charity, it is dignity. But beyond infrastructure, we must ask, can person with disabilities truly access justice when they need it most? Let me share a small but a powerful story. A young woman from a village from South Goa got in touch with us, with my office. She's visually impaired since birth, had faced discrimination in accessing her rightful inheritance. She approached our office with courage, but initially hesitated to approach the court, not because the law was unclear, but because she feared the courtroom would be inaccessible physically and emotionally. With the help of legal aid and support, they were kind enough to come forward. She was eventually able to file her case, and the court showed sensitivity and fairness. But the experience left a question ringing in our minds. How many others are silently excluded from justice because of fear, inaccessibility, or lack of awareness? This is where the role of judiciary becomes so vital. And this is why we must work closely with our courts to ensure not just physical accessibility, ramps, lifts, signages, but also procedural accessibility, interpreters, digital formats, simplified legal information, and trained legal personnel who understand the different aspects of disability. There is a silent need for greatest awareness in the country, not just among persons with disabilities, but also among government officers, lawyers, clerks, and judges. Accessibility is not just a building code, it is a mindset that should guide every public interaction. When we organize events like Purple Fest, when we call it as a movement, the main objective is not about having exhibition or experience zones or entertainment evenings, but the major goal is to change the mindset and change the narrative. And over a period of time, I think we are slowly moving towards that. We find more awareness in the community at large. In recent months, we have been engaging with the High Court of Bombay at Goa, thanks to Justice Valmiki Menezes and the district and the sessions courts to explore how courtrooms can be made more inclusive. I would request S. Govindraj, Commissioner CCBD, to kindly come on stage and take his seat. Let's give him a big round of applause. The response has been very encouraging. The new building that North Goa district has is fully accessible in all respects, and it was inaugurated recently. Justice was also there present during that time. But we need to take it to the other taluka levels as well. We need accessible legal aid clinics in talukas. We need outreach in local languages, which is already there, explaining that justice is not out of reach. People in Goa from Kankona to Perne must feel that the doors of justice are open to them in every sense of the word. This is why today's event is more important. It brings all of us from the judiciary, executive, civil society, and community on the same page. It reminds us that policy must connect to people, that law must speak the language of inclusion, and that accessibility must begin with awareness. I will not take much time. Once again thank Justice Oak and Justice Valmiki Menezes for giving us this opportunity to host this session here, to Mission Accessibility entire team who have curated this session. We had a similar program last year, during last year's International Purple Fest, again was curated by them. And I'm sure something good will come out of this today's conference, and we will talk more about inclusive society and including everyone as we march ahead. Thank you so much. Thank you so much.
Thank you, Mr. Pavaskar, for setting the tone for today's discussion and for your continued dedication to accessibility and empowerment. Up next, we have Advocate Rahul Bajaj, who will introduce the vision of mission accessibility and the core objectives of this workshop.
God, where is the mic? Yes. Good afternoon, ladies and gentlemen. Justice Abhay S. Oak, retired Judge, Supreme Court of India. Justice Valmiki Menenes, Judge, Bombay High Court, Goa Bench. Mr. Govindraj, Commissioner for Persons with Disabilities. Shri Ambasta, Deputy Chief Commissioner for Persons with Disabilities. And Mr. Pavaskar, State Commissioner for Persons with Disabilities, Government of Goa. Ladies and gentlemen, all the judges who are in attendance in the audience, members of the press, thank you very much for being here. And I'm very grateful to the Goa SCPD and to the government of Goa for giving us an opportunity or a platform to put forward, our agenda and vision for how we can expand access to justice for persons with disabilities. Yesterday also happened to be the third anniversary of Mission Accessibility, our organization, and therefore, and thank you. And therefore, we thought it fit to kind of combine our annual day with this conference. On previous occasions, we've had annual day celebrations in Delhi. In 2023, our annual day was delivered by Justice A.K. Sikri, and in 2024 by Dr. Justice S. Murlidhar. But we thought, why not have it in Goa this time? Let me tell you a little bit more about Mission Accessibility, or MA as I shall as I shall call it. So MA is a cross disability legal advocacy platform. It was formed, to address the problem that we are all too familiar with, in that we have a strong law on paper, the RPWD Act 2016, in line with India's commitment under the UN Convention on the Rights of Persons with Disabilities. But implementation on the ground remains weak. When it comes to accessing justice, education, employment, and infrastructural facilities for persons with disabilities. The important thing is to recognize that none of the guarantees which the law provides are self executing. So you need someone on the ground to address those rights violations and address the systemic gaps in implementation and enforcement that exist. Otherwise you will just end up perpetuating the cycle of violence and rights violations that occur. Justice Oak once very famously, when he was a Supreme Court judge, remarked that so many people in India, continue to suffer in silence because they can't exercise their rights. When such is the position qua the general citizenry, we can only imagine how much harder it is for those who are on a weaker footing, even compared to their able-bodied counterparts, which is persons with disabilities. Uh, so there are two, what we do really, right? So it's around, providing pro bono legal aid at scale to persons with disabilities. That is one critical part of the work we do. Even as we speak, we have about 20 cases ongoing in different courts across India on behalf of persons with disabilities on a pro bono basis. We also undertake strategic litigation, on issues that don't affect a particular disabled person, but the citizenry at large, the disabled citizenry, and also work with the government when it comes to pursuing policy and systemic reforms. So we do this work through what is called, Project RPWD Generation, which is a term that the Supreme Court used to define, to describe a generation of persons with disabilities, which the RPWD Act envisions. uh, just to give you kind of an example of the kinds of cases we take up, to give you a flavor or the kind of support that people with disabilities needs. One such case is of a caregiver of a person with a disability who is, seeking a transfer to a location where the child is situated so that the parent may be able to look after the child who has paraplegia. Other kinds of cases are around posting and transfer, because the environment where the disabled person is posted is inaccessible or where they don't have medical facilities. And one of the major contributions is through is our work on digital accessibility, making apps and websites available in accessible formats. And we also, apart from a non-profit, run a for-profit law firm called Zen Access Law Associates, through which we take up cases on disability rights and beyond. Because what that addresses is two stereotypes, right? Number one, we should not assume that all people with disabilities can't afford legal aid. Those who legal services, those who can should pay for it. Why should everyone get it free of charge? Number one. Number two, why should lawyers with disabilities only be thought of as disability rights lawyers, right? They can do any other area of law as well. So these are the two sort of things we try to do through that law firm. We've also successfully, argued 35 cases so far in different courts across the board. I won't take you through them now for want of time, but you can go to our website and look through them, missionaccessibility.org. The second significant initiative that we have is, Justice Connect, which is aimed at providing legal literacy and awareness to persons with disabilities. Because not everything is about fighting a case. People sometimes just want to know what their rights are in a given situation. We realized that we would keep getting calls during the course of the day, people wanting help. So we thought, why not institutionalize it? So therefore, we started a pro bono helpline, one on legal aid and the other on disability certification related issues. Until now, we've attended to about 700 people through this intervention. We also work with the Office of the CCPD to promote access to justice for persons with disabilities. We would like to also collaborate with national and state legal service authorities, because they are the first point of interface for everybody seeking access to legal aid with a disability. And how do we, because many people don't approach these authorities because they don't know what the process is, they need someone to handhold them. So in the next 3 years, I'll close with this. Our hope is to service about 150 legal aid beneficiaries, help establish 20 landmark legal precedents on disability rights issues, also organize 10 legal camps, organize and put together training modules for legal service authorities on disability rights law, and deepen partnerships with disability commissions. uh, and I'm very grateful that I'll just say one more thing before closing. Justice Oak, I spent a great deal of time this morning going through all of his jurisprudence on disability rights, and it shows a great deal of compassion. I'd recommend that you read his judgment in the case of Union of India versus Ajay Kumar Srivastava, which dealt with a person in the civil services who was not given appointment for years, by the government, despite them having backlog vacancies in place. And Justice Menendez has also really gone above and beyond, the call of duty in terms of working on this issue, as evident from the interactions one has had with him over the last 2 to 3 days. So once again, thanks very much for being here and for giving me this opportunity.
Thank you, Advocate Bajaj, for that thoughtful context and your tireless advocacy in making our legal system truly inclusive. Before we move on to our next speech, I would like to warmly welcome two of the dignitaries who have now joined us. I would like to introduce Learned Senior Advocate Coelho Pereira. May I call on stage Professor Savio Falero to welcome Senior Counsel with the bouquet. We have with us today Shri S. Govindraj, Commissioner for Persons with Disabilities, Government of India. I request Dr. Manoj to warmly welcome him with a floral bouquet. I now request Shri S. Govindraj, Commissioner for Persons with Disabilities, Government of India, to kindly address this gathering.
Very pleasant noon to everyone gathered here. Most revered, honorable justice present here and senior counsels and dedicated delegates who have come to witness this meeting with full interest and involvement. I wish you a good noon to everyone, and I shall take this pleasant moment to narrate what kind of the grievance redressal system we do have as a boon for the Divyang community. And let's view some of the challenges that our community as well the system faces. See, as for the RPD Act 2016, we are provided with several opportunities and provisions to approach for justice with a free and a fair manner. It could be assessed in a different layers, right? For example, both the government and private sectors are advised to have an equal opportunity policy to ensure the equal treatment of everyone without any discrimination, right? At the workplace or in the society. When we look into the system, the Act advises wherever there are more than 20 employees or employed, it's a mandatory to have a liaison officer to hear the problems of the differently abled employees. Likewise, it insists upon the nodal officers in institutes and grievance redressal officers in all the concerns and companies, corporates, wherever. All right. So these are a legal provision for us to protect our rights. And beyond that, we have a greater authorities like CCPD, Chief Commissioner for Persons with Disabilities, the office comprising of one Chief Commissioner and two commissioners, and state commissioners to all states and union territories. So these authorities have the power to investigate, inquire the complaint they receive or the complaint which appears in the society can be taken as a suo motu to provide a better approach and towards the redressal. So likewise, the Act is strong, advising the society to abide by it. And as I told you, it has provided an excellent system of establishing special courts and insist to appoint a special prosecutors, public prosecutors. So this much it has done towards the grievance mechanism, right? And it is very evident that RPD Act provides penalty classes those who violate the rules or the non-compliances and the offense against the Divyang, right? Which amounts to 10,000 to 5 lakhs and 6 months imprisonment to 5 years. Rules are very strong, no doubt. We should thank for the policymakers and the legislatures for enacting this and the judiciary system for enforcing it. But we believe there are some practical problems in implementing it and monitoring it, right? As we all aware, though we have several provisions, those are not practically maintained or practically established, right? Most of the recruitment authority do not know the reservation provisions, and most of the administrator do not know what all the rights or special provisions provided by the law for their empowerment. This needs to be sensitized and trained as Judicial Academy does with the judiciary. We need some compulsory capacity building programs within our system, right? And it is the fact that the orders, whatever the CCPD and SCPD makes, do not have the adjudicatory power. It has got only non-binding orders, right? It has the nature of a recommendatory, or so many times it sounds to be obligatory, right? Because the non-compliance doesn't attract punitive action or any serious effects. So that could be viewed and reviewed in the days to come. And to strengthen further, we need to implement all the provisions. We need to establish, right? We need to provide free legal aid through NALSA and SALSA, right? And by establishing special courts for a speedy trial and speedy judgment for the Divyangjan, right? And because of some good organizations, associations, and activists, several issues are taken to the high courts and Supreme Courts to get the RPD Act interpreted and implemented. So we should thank such an activists and advocates for taking interest for the welfare of Divyangjan. Right? Likewise, we require more power. The power should be enhanced to enforce the commissions. The state commissioner and CCPD should be provided more supervisory power, evaluating power, right? It is well mentioned in section 75 to 77, though it is not in practice. So we need to make the powerful policy into practical abilities in order to strengthen and empower the differently able community. Right? So we need to, this is the appropriate time. Having enacted in 2016, it completes 1 decade by this year. So it's a right time to conduct more brainstorming sessions, seminars, over these acts for for more recommendations, positive recommendations, right, to be included for the amendment and for better empowerment of our beloved Divyang community. Really, I wish to congratulate the Mission Accessibility and Government of Goa, the ACPD of Goa, for organizing this event, right? Mission Accessibility has got a strong vision to take it forward. So we are proud to say that we are also collaborating with them, and we are prepared to collaborate with many more who are with a similar interest to empower our community with a greater ideology and to strengthen the system. So once again, I thank all the honorable judges present here for having spared their valuable time to strengthen our system. And this proves that access to justice, Section 13, is implemented very strong by this program. So thank you, one and all. Jai Hind, Jai Bharat.
Thank you, Shri Govindraj, for those insights and for your leadership in implementing national level disability rights policy. We now invite Honorable Justice Valmiki Menezes, Judge at the High Court of Bombay at Goa, to address this gathering.
Honorable Justice Oak, Judge Supreme Court of India, my friends on stage, in the audience, both in physically present here and virtually present. The color purple historically used to represent nobility, but it has been aptly chosen, I believe, by the Purple Fest, the government of Goa and the organizers of the Purple Fest, as it also stands as a symbol of power, dignity, and independence. The Purple Fest is well, people call it a festival, but as Guru Prasad rightly said, it's a movement, to not only celebrate persons with disabilities, but to get people together. They come together to create an inclusive world, to make sure that our society is inclusive. The festival, I think, is in its third year. Second year, I think, for the High Court and the Goa State Legal Services Authority to have a tie-up with the organizers. The Goa State Legal Services Authority is an authority set up by under the aegis of the Legal Services Authority Act. And if one looks at the preamble of that act, what the act mandates is to ensure the opportunity for securing justice, economic, for the persons who are with disabilities which are economic or other disabilities. And keeping with this preamble, the Legal Services Authority organizes workshops and awareness programs. Of course, one of the major thrust is to make sure that persons of any kind of disability, whether it's because of their gender or other kinds of disability, are given free legal aid, given legal assistance, so that they have access to justice in courts, they have legal advice given to them. So this is one major reason why we believe that associating ourselves with movements of this sort would take us a long way in making sure that our society becomes aware of not only what is the legal framework, what are the rights of persons with disabilities, but making people more sensitive to persons with disabilities who are part of our society and have equal rights. Let me take this opportunity and tell you about what's the first time for today's conference workshop here in the High Court. This is the first time since we have tied up with the Commissioner of Disabilities that we have to ensure a wider uh, audience and a wider awareness being created. We have created you are actually up on a YouTube channel, and you are also, we have an interactive system over Zoom, where for the first time, all our judicial officers are online, in whichever station they may be. And also as a first time, I believe, thanks to the IGP consenting to having a large number of police officers part of this workshop. Many of them I see are online. They've joined in online. And that's very important for building up this awareness. It's very important for society to know that the law enforcement agencies, the judiciary, and the legal services authority work hand in hand to ensure that the impact of what is required by the Disabilities Act is carried through. Since the principal district judges are also online, may I request and take this opportunity to request them, as one of the speakers earlier said, we must ensure that in public service, wherever there is a roster point system where a position is reserved for persons with disabilities, they must be adequately filled in. They're not meant to be left for general category candidates to fill in. At the district level, the endeavor should be to make sure that all these positions are filled in. And even otherwise, we have to make sure that the systems, as Guru Prasad said, we have been bringing about a sea change in the structures of our buildings, in the facilities available. But I believe, and this is an admission, we are lacking in other things like persons who can use sign language. So we need to train our own staff. We need to train people in courts how to use different forms of language that persons with disabilities use. We have to train our staff how to be sensitive to their needs. It's just not constructing toilets and ramps, as Guru Prasad says. It's about sensitizing ourselves to their needs. So let's start this change right away, and we hope by the next festival we would see a lot of movement in this area. There's another aspect of this movement also that I'd like to share with you. The courts, by their very nature, instill a sense of fear in our citizenry. In these past couple of years, it's been our endeavor not only to construct court edifices in such a manner that are more conducive to or create less of a fear and are more open to citizens, but it's also going to be our endeavor. I can say that for the High Court as a start, that we would, with these kind of programs, keep more and more spaces within the High Court. And I do believe also it would happen in the district court. The new North Goa District Court building is really well designed for that, which are more open and more welcoming to citizens. It's a should be a place that doesn't cause any fear, but causes a sense of um, bringing a sense of faith and confidence in our citizens. So I use this workshop as a platform to uh, you know welcome you to the High Court and send the message around that the High Court and other court buildings would be more sensitive to the citizens' needs and expect to create an environment that would be less heavy and stressful to litigants and the citizens. Um, I must also take this opportunity of making a special mention of both the um, interaction that I've had with both the Government of India Commissioner as well as the State Government Commissioner for Disabilities. Guru Prasad has been really at it, keeping us constantly engaged to see that this workshop is a success. We intend to have more of these workshops, not once a year, but more to sensitize people throughout the year. And I must also thank the High Court Bar Association. They've always been very supportive of all these programs that we've had. And most of all, I must thank Justice Oak. It just took one phone call. His reaction was immediate for a program of this sort. He says, "There's no way I'm going to miss it. I will be here." Thanks, Justice Oak. And um, we are looking forward to the interactive program. I'm sure soon after Justice Oak finishes his address, we will have an interactive program. Please interact as much as you can during that session. Thank you.
Thank you, Your Lordship, for your powerful words and your commitment to a justice system that includes everyone. I am truly honored to now welcome our chief guest, Honorable Justice Abhay S. Oak, retired judge of the Supreme Court of India, to deliver the keynote address on the theme Promoting Access to Justice for Persons with Disabilities, a roadmap for the next decade.
This is not a function where I should follow the etiquettes of meeting by taking names of persons sitting on the dais. But I want to thank today, I want to start with thanking Brother Justice Menezes and Mr. Guru Prasad for different reason. I must say that after coming here, I'll go back enriched. First reason is that after demitting office, I have more spare time. So I looked at the Disabilities Act in different perspective. And actually, because I was invited by Justice Menezes, I had to do that. But the real learning experience was today when I visited Purple Fest or Purple Movement, as Mr. Guru Prasad rightly called. It was a great learning experience for me. Few things I learned, I must share with you. We as judges, we also work as administrators. We felt that if we provide accessible toilets to persons with disability, we have performed our duty under the Act. But today there was one gentleman who has done a great deal of work. I learned that merely providing accessible washrooms and toilets, providing those bars is not enough. The equipment installed there must be disabled friendly. So there's a huge lesson which I learned. And second lesson which I learned, there was a young artist from Bangalore drawing some pictures there. And she was enjoying the entire atmosphere of the fest. I could see the joy on her face. And there are many things, the list will be endless, which I learned after visiting the fest. I was associated with the State Legal Services Authority. In Maharashtra, we used to have these mega legal aid fairs, and where one section always used to be about providing facilities to the persons with disability. But I don't think we even thought of planning that event on this scale. So I must thank Guru Prasad, his colleagues in the state government, and uh, many other institutions who have contributed. Today, actually, there are better equipped persons than me to address this August gathering. We have Mr. Rungta, senior advocate. I mean, hearing him in Supreme Court was always a pleasure. We have Rahul Bajaj and many other lawyers who are working in the field. Before I touch today's topic, I make one request to Justice Menedis and Registrar who is sitting here. Please request all judicial officers in the state to visit this fest. It's such a great learning experience. And because most of the judicial officers are online, I will tell you why I feel that that is necessary. We have Maharashtra Judicial Academy where we train our civil judges and district judges from both Maharashtra and Goa. There is an institution in the same district where Judicial Academy is there, which is a residential facility for intellectually disabled. And I am always regular faculty member teaching the young civil judges and magistrates. So at least on 4 to 5 occasions, I insisted that my lecture should be in the precincts of this institution, because there are 40, 50 persons with intellectual disabilities staying there. So I used to request the director of Judicial Academy to take all the judicial officers in bus early in the morning to that institution. They used to go there. They used to have breakfast there, lunch there. And in the afternoon, I used to have my lecture. I realized that at the end of the day, the judicial officers were extremely enriched after they interacted with these people. They understood their needs. They understood where as society we are failing in our duty. So if our judicial officers visit this fest, they will be enriched. I have to request to Senior Advocate Coelho Pereira to request members of the bar also to visit the fest. It's very, very, very necessary for them, because their approach to the problem will change. Now, today, the subject is about legal rights and empowerment of persons with disability. Now, holding such workshops is a very noble initiative. When we talk about the Disabilities Act of 2016, I think we must understand the constitutional perspective also. Where all of us know that there was a convention on the rights of persons with disability in December 2006. India is signatory to that. Therefore, based on that convention that we have this law. But if you look at the provisions of this law very carefully, firstly, Section 3, which talks about equality and non-discrimination. Then Section 6, protection from cruelty and inhuman treatment. Section 7, protection from abuse, violence and exploitation. Then protection and safety, reproductive rights, accessibility in voting and access to justice. Apart from the international convention, you will find that these provisions give effect to two very basic fundamental rights under our constitution, that is Article 14 and 21. So we must also remember that this law has been enacted to implement the chapter on fundamental rights. And then there is a section 12, which deals with access to justice. Mr. Rahul Bajaj messaged me that he expected me to address on this. Actually, if you see the concept of justice in preamble of our constitution, it is not confined to justice which is delivered by the traditional courts or tribunals. It is justice which is social, economic, and political, which will also include the justice rendered by the justice delivery system. But somehow, Section 12, if you see, it limits access to justice by saying that the appropriate government shall ensure that persons with disabilities are able to exercise the right to access any court, tribunal, authority, commission, or any other body having judicial or quasi-judicial powers or investigative powers. So, if you compare justice contemplated by Section 12, it is slightly narrower compass than justice which is contemplated by our preamble. And I think as far as Section 12 is concerned, of course, it talks about responsibilities of National Legal Services Authority and state legal services authorities constituted under 1987 Act to make provision for reasonable accommodation. I'll come to that little later. But I think one part of Section 12, I don't think we have implemented in letter and spirit. That is subsection 4. Now, of course, subsection 4 puts responsibility or obligation on the state government and not on the judicial wing. It says that the appropriate government shall ensure that all public documents are in accessible formats, to ensure that filing departments, registry, or any other office of records are supplied with necessary equipment to enable filing, storing, and referring to the documents and evidence in accessible formats, and making available all necessary facilities and equipments to facilitate recording of testimonies, arguments, and opinions given by persons with disabilities in their preferred language and means of communication. Now, perhaps this subsection 4 is one area where we, the members of the judiciary, we have not complied with in letter and spirit. And therefore, I think collaborative effort is required on the part of the state governments and the judiciary. Now, looking to the initiative taken by the government of Goa, now Goa has gone far ahead of other states. So perhaps Goa being relatively small state, actually the judiciary and the government can act together and ensure that all courts in the state are subsection 4 compliant. Is easily possible in smaller state like Goa, and especially when government is willing to go ahead. That's very clear from the initiatives which I saw of the government, which were reflected in that fest. So this is one thing where a smaller state can Goa can become ideal and it can set an example. And there is a corresponding section to Section 12 under Disabilities Act, which is Section 12 of the Legal Services Authorities Act 1987, which says that gives the list of persons who are entitled to legal services. It's not merely legal aid, legal services. And it includes the persons with disability, of course, defined under the old 1996 Act. So basically, it recognizes that a person with disability will be entitled to legal services under 1987 Act. Now that legal services are multifarious services, like giving legal advice, filing cases, appointing lawyers, etc. If we take a review of the implementation of this act, perhaps one area where we have to now concentrate is about the awareness campaign, which is contemplated by Section 39. Rahul Bajaj referred to what I said in one of the judgments. You know, in our country, we always talk about docket explosion, that huge pendency and huge filing in our courts. But equally worrying is docket exclusion. I have said in the context of women who suffer injustice due to demand of dowry or many other things. And we talk about abuse of Section 498A by women because those cases come to the court. But there are large sections of women who silently suffer the atrocities because of social reasons, economic reasons, and various other reasons. They even can't think of approaching the police or approaching the court. Now, same is the case with the persons with disabilities. Now, therefore, there is section 39. Now, section 39 is, of course, about reaching the persons with disabilities and making them aware of their rights under the 2016 Act and, of course, their rights under the Constitution. Because, as I said, there are many other provisions also which find support from the Constitution, like Section 24, which deals with social security, 25 deals with health care, because ultimately right to health is also guaranteed under Article 21. Then there is insurance scheme. Then there is Section 27, which deals with rehabilitation. Then there is Section 31, which deals with free education for the age group of 6 to 14. Then there is a section which Section 32 provides for reservation in higher education. So all these provisions, the foundation may be in the international convention, but also in the Constitution. So when we talk about Section 39, is of course the first step is to make persons with disability aware about their rights. But more than that, it is also necessary that the others must be made aware about the rights available to the persons with disabilities. That's very important. See, ultimately, there is something known as fundamental duty. If I have fundamental right of freedom of speech and expression, or fundamental right to carry on business or occupation in any part of India, it is also my duty to ensure that the others also are get that right, others also enjoy that right. Similarly, those who do not form part of those 27 categories of persons with disabilities, in fact, they need to be educated more about the rights of persons with disabilities, because their approach has to undergo change. And I'm talking about judiciary. No, we who are members of the judiciary, our hands are full in the sense that we have to deal with so many cases which are being filed. Sitting in High Court, we have to deal with 100 cases, 150 cases. In Supreme Court also, more than 50, 60 cases on Mondays and Fridays. So we also commit that mistake of not taking adequate steps to implement the provisions of Persons with Disabilities Act. In fact, sitting in Bombay, I had delivered a 200-page judgment on what should be the judicial infrastructure, and where I said that it is a constitutional obligation of the state to provide adequate infrastructure to the judiciary. Whereas this is one topic which is left out from that judgment about giving effect to the rights of persons with disability. But what is important in that judgment, and now that is actually the judgment of Supreme Court subsequently, that it is the constitutional obligation of the state to provide very good infrastructure to the judiciary. Now that infrastructure will also include the infrastructure which is required to be provided to the persons with disability. Mr. Pavaskar, I was sitting here on the dais. I mean, he made a very important suggestion. And in fact, in the morning, I was thinking about it, that we should have this awareness campaign in our schools and colleges. But he made a very important point that in our law schools and law colleges, in our syllabus, Disabilities Act is not included. That is also a very valid point which he has raised. At least the young lawyers, I mean, the students of law must be exposed to this act. And of course, now today, I'm in better position to do that, because practically once in a week, I am going to different law schools in our country and delivering lectures on. I talk to the vice chancellors of some of the national law schools also, and request them to have at least 2 or 3 lectures on the Disabilities Act, because that is where the process of sensitization should start, because some of them will become legal professionals, some of them will become judges. And of course, we expect them to become good citizens of India because they are undergoing law courses, training in law. So that's a good idea where this subject has to be introduced in our law schools and law colleges. One area where we are lacking, I have seen, that is, of course, Section 40 talks about standards of accessibility of physical environment, the transportation, information, communication, etc. Section 41 again talks about access. Section 44 is very important according to me. mandatory observance of accessibility norms. So it says that no building permission should be granted unless the plans are complying with the rules formulated by the central government. And those harmonized guidelines are there. They are referred in, I think, Rule 15 of the central government rules. I somehow checked, in every state, the town planning acts are there. There are municipal laws which deal with building permission. But I have not come across development control regulation talking about state of Maharashtra. There are development control regulations which deal with aspect of sanction of building plan, grant of FAR or FSI, whatever name we call it. But I don't think that in the corresponding municipal laws or town planning laws, effect is given to section 44. And therefore, now this section 44 applies to all buildings, not only public buildings. So I think the commissioner of the central government is here. I think we need to work on that we must provide in our municipal laws and town planning laws about strict compliance with section 44. So no plan could be sanctioned unless it complies with the requirement of the Disabilities Act. I have not studied, of course, the local laws of Goa. Will be happy if local laws of Goa provide for it. I studied local laws of Maharashtra, Karnataka, and some other states because I wanted to know whether there is compliance with section 44. So this is one area where the state governments will have to act and ensure that section 44 is complied with. There are several other aspects of compliance with the Disabilities Act. See, there is section 35, which provides that the central government and state governments must give incentives to the private players in the industry and business to provide for employment, 4% or 5%, whatever is that provision. Now we need to consider whether such incentives have been provided or not, because there is a reservation that 3% or whatever is that percentage in the government jobs. I was just discussing with Mr. Pavaskar that whether there is a census of persons with disability who are covered by the Act. There's no census, but he said that broadly it will be 2 crores and more. Now, government jobs will not be enough. See, the crux of the issue is persons with disabilities must get opportunity to take education, higher education, and then employment. Because ultimately they have also right under Article 21 to lead dignified life. So I think we need to work on this. In fact, I remember about 2 years back, in some other connection, we had a meeting with some of the senior officers of the central government. At that time, myself and one of our colleagues had raised this issue that why don't you give some concession in GST, for example, to those industries or those offices, private offices, who will provide for, say, 5% job opportunity, 5% seats reserved for persons with disabilities. Now, that is one area where we have not worked. In fact, yesterday I realized that there was a function in Bombay. Now, there is a new profession now. That is known as new professionals now, compliance professionals. They are lawyers, they are chartered accountants, they are company secretaries. They ensure that the industries and business houses, they comply with the laws and they comply with laws by following ethical standards. So yesterday I raised that issue. I said that there are all leading figures of building industry and other industries yesterday. So I said, there is a section 35. The government may not have given you incentive in terms of, some tax concession or something. But the biggest incentive for you to employ people with disabilities is the great satisfaction you will derive of giving life to a person with disability. So even on section 35, we need to work more and more. The last thing is two things which I want to say. One is the penal provisions in the Act. Now, there is a chapter containing penal provisions. I'm not going to read those penal provisions. Chapter 16 lists out what are the offenses. I personally feel that, the penal provisions under the Act must be more stringent. I understand there's a section which says that no court can take cognizance of offense against a government official unless there is a government approval or sanction. I understand that. But unless we make these penal provisions more stringent, uh, we cannot actually ensure compliance with the uh, provisions of the Act. So that is one area where I think the government needs to work. And the last thing which I want to say is about pending cases in our courts. Now, most of the pending cases are about rights of persons with disabilities. I mean, Mr. Rungta is here. I'm glad that he's here. He's going to address you on some of the aspects. Sitting in Supreme Court, I found that those who had come to the court for seeking employment, I mean, they were not seeking employment, they were seeking enforcement of the reservation, which is provided under the Act, which is again consistent with the concepts under Article 14 and 15. Those cases were delayed. And therefore, the question which arises is whether some priority can be given to the cases where the persons with disabilities have gone to the court of law for enforcing the obligations of various entities under the Act or for enforcing their own rights. See, this is one area where I have spoken very in detail in all platforms, even as a sitting judge in some of the judgments. See, somehow in our system, our legal system, we have not fixed our priorities rightly. And therefore, we have to write that constitution bench judgment that higher court should not dictate to the other courts that you decide a particular case within 6 months or 9 months or 10 months or whatever is that time. So we don't have those priorities. We have one priority guideline issued, I think, in 1996 by the Supreme Court that cases of those who are senior citizens should be given priority. In my judgment, also on public platforms, I had joined issues with that. I mean, what is the necessity of giving priority to in block priority to cases of those who have crossed 60? Now, we need to have priorities fixed, whether priority should be given to the matrimonial disputes or priority should be given to the cases in the POCSO Act or priority should be given to the habeas corpus petitions. Similarly, now we need to think about it that why priority is not given to the cases filed in the court for enforcing the rights under the Disabilities Act. So this is one issue which we'll have to address. And then what happens in Supreme Court, the job of judges is very easy. When we see injustice, and there are good lawyers who assist us, so it is very easy for us to exercise power under Article 142 and do the substantial justice. But that does not happen when cases are pending in the High Court. And sometimes, the delay in disposal of these, especially these cases concerning failure to provide reservation. Now, delay creates several problems because the person who comes to the court, a person with disability comes to the court with great expectations. He remains without any employment. And then question is whether he should be given back wages, how his seniority will be protected, several issues arise. So this is one area where members of the judiciary will have to really think about it, that what kind of priority can be given, not only to the cases of persons with disabilities, but other cases which deserve priority. I think this is just an introduction about what I feel about the Disabilities Act. I think there are speakers who are well versed and more experienced than me who are going to address you. So I again thank the organizers of this event for giving me this opportunity, to learn, I will say, to learn and put across my thoughts. Thank you very much.
Thank you, Justice Oak, for that profound and visionary keynote that has given us both direction and hope. We now open the floor for a brief interactive question and answer session with our dignitaries. This session will be moderated by Advocate Rahul Bajaj.
So those who'd like to ask questions on Zoom should raise their hands. Members of the audience can also raise their hand, and I'll request my colleagues Shireen and Amritesh to just help in picking one or two questioners from the audience. But let me first abuse my privilege as moderator and ask a question of my own, which is, Justice Oak, I'm keen to know what is your view on the appropriate interface between the various grievance redressal bodies that are there under the RPWD Act. So, one, we have the Chief Commissioner and State Commissioners for Persons with Disabilities. Uh, we also have special courts, which are under Section 84, which are courts of session, which are to be designated as special courts. And then the ordinary constitutional courts also one can go to for enforcement of for writ petitions or to CAT for service matters, etc. So how should we properly demarcate the jurisdiction between these various adjudicatory bodies?
Rahul, actually, one point which was in my mind, I forgot. After I went through the act, there are commissioners, chief
Yes.
commissioner at central government level or chief commissioner at state government level. We call it as grievance redressal mechanism, but I don't think there is enough, there are enough provisions which ensure that the recommendations of the commissioners are implemented.
Yes.
Because they are all in the realm of recommendations.
Yes.
So there is hardly effective grievance redress mechanism. So that is where I think we need to amend the act. Because see, ultimately, uh, commissioners have to play important role.
Yes.
But their role ends under the act by only recommending it.
Yes.
So therefore, we need to give teeth to their power. That is number one. Because that is the basic grievance redress mechanism which is available under the act.
Yeah.
And other grievance redress mechanism is to go to the court. Maybe under Article 226, maybe 32,
Yes.
or maybe ordinary civil code. So I think that's a big gap and void
Yes.
which we need to fill in.
Right.
May I ask my question now? sir?
Yes. Yes.
Rahul, this is Kanchan. So Kanchan Pamnani, Bombay High Court solicitor. So couple of things here. Section 7, your executive officers, executive police for the abuse part. We don't have a list. We don't know where to go, where to send people from the NGOs. Even as a lawyer, I don't know where to go, though I'm just outside the state police headquarters. So there's nothing about a list of executive officers under Section 7. We don't have anything in Goa or Bombay out there. When Justice Mohit Shah was Chief Justice of Maharashtra, of Bombay, there was a list. We had a listing for persons with disability. We actually had a listing there. So that is the only time we had it. Then, of course, it got very, very, very urgent cases only would come up, and they wouldn't come up at all, actually. So that's the only thing I like to say. But the third thing I'd like to say, as a lawyer, a lot of cases are filed online now. A lot of cases are now in scanned copies. We still get a bad scan. We do not get what the court gets. If my other side is serving me, he's just sending me an ordinary scan, not a readable copy. So that's a little difficult, and we're trying to change that, but it's not become compulsory. So somewhere along the way, systems fail at the actual practical level. So we just like a little bit on that. If we could, how do we enforce it? How do we push it? Thank you. Sir.
So basically, you are on issue of non-implementation of machinery created under Section 7.
Yes, sir.
Right. So where there is a cases of abuse, violence, and exploitation, because of course powers are given to executive magistrates also under subsection 3. But as you rightly said, you don't know where you should go in such cases. Actually, these cases should be taken up with the government, I believe, because I don't think implementation of Section 7 can be that difficult. Again, it's a question of, again, creating a machinery, notifying the places where people can approach when Section 7 can be invoked. About the other part, use of technology. Of course, there I must say that we lack so many things because, problem is in most of the courts, we don't have adequate bandwidth. So adequate IT structure is not there. But that is no excuse for not complying with subsection 4 of section 12. Actually, what you say can be taken care of if subsection 4 of section 12 is implemented. So that's also a point is well taken. I believe Brother Menezes is part of E-Committee of Bombay High Court, and surely I think he can take up this issue.
Definitely. Point taken. I think we lack in the uh, infusion of some technology here, obviously. So this is something definitely I would drive through the computer committee of the Bombay High Court. And we see that it trickles down to the district levels as well. Why should it just be at the High Court level? It has to be implemented at the district court level as well. But immediately on reopening, this will be taken up as an issue. I made a note of it. Thanks. Thanks for bringing it to our notice.
Mr. Rungta has a question, I believe.
My Lord Justice Oak, I just wanted to point out another important gap, the point that you were making about the delay in giving justice to a person with disability seeking enforcement of reservation. Nowadays, I have also seen a problem in implementation of scheme of reservation in terms of enforcement of their right in the courts. Normally, the advertisements which are issued do not provide for proper reservation. And if you approach court challenging it, then you need an individual. Maybe individual may not be that aware of his right or the defect in the advertisement. Now, therefore, the best remedy is as a class of persons with disabilities to take it in PIL. When you approach high courts in PIL, I have myself experienced it, the first question comes that, no, this is a service matter. But maybe technically you are right when you say this is a service matter. But this is not. It is enforcement of the right of reservation, which has been denied in that given advertisement. A may be eligible, B may be eligible, that is immaterial. But you are somehow postponing the implementation of reservation, which you very rightly pointed out, my lord, in that judgment of Pankaj Srivastava.
If I may add a related aspect, Lordship, is also that because we have also experienced it that when you file a PIL, you're supposed to provide the data on non-implementation, which is not available in the public domain. So as a petitioner, it is very difficult to get a department-wise data that there has been non-compliance.
In fact, I must, Mr. Rungta, absolutely right there. Because whether judiciary is giving effect to the reservation, that's the right question. In fact, when we are coming to the venue, in fact, Brother Menes raised the same question that we need to work on that. Actually, we can start with Bombay High Court so that we can, because you are right there. I mean, judiciary has to also take lead and provide for a reservation, identify the post where persons with disabilities can be appointed. And about the non-entertaining PILs, it's very unfortunate. It should not happen because in such a cases, when you come to the court, you are in Article 226, where you want to really enforce the obligations of all public authorities to comply with the act. So that should not happen. I mean, it's a correct issue which we have raised.
Speaking for the Bombay High Court, of course, your point taken. Perhaps as far as Goa is concerned, I think there are a couple of NGOs who have filed PILs on this issue. I don't know if those are disposed of, but if they are still pending, I think we should fast track those hearings of those matters. And this is the point I was raising also that the roster point system where there is a reservation. I appeal to the district judges here that in their districts they enforce it at least in the district judiciary, but I think we need to enforce that provision across the board. So from the Goa point of view, of course, I think we would take cognizance of it and try and implement it. Yes.
So maybe two questions offline and one online we can take, and we can close on that. Okay, so sure.
Lordship, may I just say that we have whenever our myself, Irshad Aga, Principal District Judge, North Goa, Lordship. Whenever roster has come, we have selected persons because in North also we have one deaf and dumb who, if I am not wrong, she has been from LDC, she has been promoted to a UDC also. And I had an occasion when I was posted in South Goa, I had a tough time because she was a small girl and she had a brother, elderly brother. So a category of deaf and dumb. I had to select her as a peon and she looked to be very thin. But before me, a post of a reservation. And secondly, what was happening is that she was looked after by the brother. And then thing came to me that maybe the brother is trying to take advantage of the situation, trying to get it this. But I prevailed by say I saw that she was selected amongst the means whatever best was from the cadre from that this reserve category was taken. Then secondly, Lordship, similar situation arose when we see that a person could not see. So what happens is that when they be when they are come for LDC post, we have to give them typing test, but that is required. And then we have to give them as per their requirement because they have a particular requirement. Then we have to bring that system and give them this test. Not only that, then those tests to be given. Normally, they have to be typed at a small words, but they have to be given a screen which is provided with a big this fonts and all. We have done that. Even a person who cannot see, we have selected. If I'm not wrong, in South Goa, we have a staff peon level who cannot, who deaf and dumb, and in somewhere in Vasco, if I'm not wrong, a person who cannot visually impaired little to some extent, and in North Goa, we have again a deaf and dumb lady.
If I may just request you, because it's just not a question of appointing a person, but there are several kinds of disabilities. It's not just a person with a visual impaired or any other kind of impaired. There are various. So I think we would be failing in appointing someone but not providing the tools because that is one of the mandates of the act.
We'll do that.
So please be sure that you enforce
We'll take care.
that other part.
Yes.
There's no point in appointing someone if you don't ensure that all the tools are made available. I understand that funds are not an issue.
Yes.
It's just we have to know where to tap them from. So we have the same issues here. So that should be the endeavor, I think, of all of us now.
We'll do that. Yes.
Thank
Thank
you.
May I speak?
Maybe one last offline question we can take before taking an on.
Sir, Okay.
I would
Yeah.
like to ask a question.
Yes. So yes.
So my question is to Justice Oka. Sir, my name is Shireen. I am an able-bodied lawyer working in the area of disability rights. So in the context of access to justice for persons with disabilities, I have observed that disability rights litigation is largely taken up by lawyers with disabilities themselves. As you mentioned that the RPWD Act 2016. So you mentioned that the RPWD Act 2016 should be introduced in the law school curriculum to make law students familiar with it. So I wanted to ask, how can we further encourage and motivate more able-bodied lawyers to practice in this area of law so that access to justice for persons with disabilities can be strengthened?
See, why I took suggestion from Mr. Guru Prasad Pavaskar was that not that we want to teach the law students the provisions of Disabilities Act, what is more important to to make them sensitized about the provisions, not only provisions, but the issues faced by the persons with disabilities and what are the legal answers, what are the legal rights and liabilities. So sensitization is the real object. And if uh, young students who are going to be lawyers of tomorrow, if they are sensitized, I'm sure that they will come forward. Some of them will come forward, take the cases.
Right, sir.
Yes, maybe one online we can take because we are also we are already short of time. I mean, the 15-minute period is almost over. I'll let Justice Oak decide. Okay. Yes.
Uh,
Yes. So these two and then no more.
Hi, I'm Janvi. I'm from Mumbai, and I was traveling recently from Mumbai with my daughter, who's on wheelchair. So my question is for the aviation part. I'm not a lawyer. I mean, most of you are lawyers and talking about the law enforcement, but this is from a side where we really come through such problems when we enter the airport. There are the rules are very well mentioned, I guess, but whenever we go to the airport, we have to face lot of going around the counters. People are not knowing the rules. I think even the staff on the airport, even though we have all the papers, it is very difficult to explain to them. These children are on wheelchair, they are disabled, they are not sick. So to prove to them that they are just disabled also becomes a task. The wheelchairs, to be put under the scanner. We have to first go to the counter, go to the CRF, again come back, get it scanned. I'm sure none of you on the dais would know what this is like, but it's really very difficult for us to travel with these children. So, my request to all of you is if something as a protocol, when a person on a wheelchair enters, and it is not for one particular airlines, it is for the entire staff, I guess, on the airport.
Uh, See, this is not only about the airports. This is about the transport, railway transport. This is about transport by buses. This, this difficulty. It is more manifest in airports. So
Probably yes, but
right.
what happens is when we
Okay.
have
So
to get
therefore,
this thing scanned.
there are two solutions. One is the commissioner sitting here. Commissioner can always recommend to the Airport Authority of India. And the other issue is, even legal services authorities do file PILs. So there can be a PIL by legal service authority, not only dealing with the issue of air travel, but issue of travel by all categories of public transport.
Yeah.
So that can be one of the solutions. And of course, commissioner can, of course, he has power to recommend, he can take up the matter with the Airport Authority of India and Government of India.
So, just to add,
One.
I know I have taken the liberty of asking question, even if I did not have. So, when we travel in foreign, when they go through these wheelchairs, the wheelchairs are scanned along with the person.
Correct.
So, we did not have to, get them down, put the wheelchairs in a separate place, So, this entire task can be made very easy if we just have the scanner put in place for people with disability.
Right, correct. That's a very valid point taken by you.
And it's not a big thing, I
Right,
guess,
correct, correct.
So
It's a
Mr.
matter of
Govindraj,
changing the procedure.
sorry, Mr. Govindraj is saying that you file a complaint with the CCPD and they look into it.
I've already filed just now with you, the entire panel. I'll definitely do that in person, but then I think, yeah, formally I'll do that. Okay.
Maybe one question online we can take and then close with that.
Yeah, this is Vaishnavi. I'm joining online. I'm not a lawyer and I'm not sure about the, propriety of asking this. If I'm incorrect, excuse my lack of knowledge. For one query I have is in public interest litigations. Is there no way that, kind of government affidavits or even the petitioner's affidavits can't be made part of the public record in the judice system because, that is very crucial if it is a public interest litigation. That connecting bit of information is left out, and we are relying only on the judgment, whereas a lot of the data on which the judgment is based, the judgment is sometimes even referring to affidavits, but the general public has no idea what it is. One example is, thank you for, kind of incorporating and bringing in the issue of disabled pedestrians in your recent, order in the S. Rajasekaran road safety case. The judgment is out, and yes, disability does, feature, not as much as the submissions we had made, but there is, for example, a reference to an affidavit, and we'd like to know what the government stand is. Also, in this, a lot of it is the Supreme Court is ultimately saying that the states will have to decide. So that kind of makes things really difficult for a person who's seeking justice, who, as you pointed out, has difficulty accessing transport, freedom to move itself on the roads, etc. If we have to go to and fight this battle, especially with buses, for example, in every court and in every state rather than just with the center.
Sure. Thank you, ma'am. So Lordship, two questions, I think. One on whether affidavits can be made public in these kinds of matters. And second, how do we deal with these issues on a pan-India basis?
First issue, I must say, ideally you are right that all pleadings which are filed in pending cases, they should be available on public domain unless there's, of course, privacy issue. Like, for example, matrimonial matters, or there are many other matters, these domestic violence matters, etc. And ideally, it should happen. But two or three things which I want to tell you from my long experience. Firstly, judiciary is not financially independent. Even if I have to purchase a pen for pens for my staff, I have to submit a proposal to the state government, and the state government has to approve the funds. Now, for uploading the affidavits and all pleadings and everything which is on the record of cases, which will require huge storage space, and there is monetary constraint because when it comes to court infrastructure, there are various aspects of court infrastructure. One is IT infrastructure. The other infrastructure is also there, constructing buildings, making provision for litigants, and so many other appointing staff. So it's a huge spending which is involved. So ultimately, some priority has to be given. And therefore, today, perhaps judiciary is not able to give priority to this. And even today also, if you want copy of an affidavit, which is on the record, there is a facility of applying for certified copy. If you are not a party, you have to file an affidavit and make out a case why you want that copy. But it will take some time for our system. It requires huge storage facility, which is a huge liability, financial liability for the government. So in an ideal situation, you are right. And secondly, these issues of persons with disabilities, they can be always taken on pan-India level by way of a petition under Article 32. That is quite possible that every time people need not go to different high courts. That is also quite possible. That's what the second query formulated by Mr. Bajaj for you.
Thank you very much for your very candid and
just add
yes,
to
please.
what Mrs. Jayakumar asked. Perhaps when we turn to a totally digitized system in courts, so affidavits which are filed, like for instance, Goa is fully digitized. We don't use paper; we are paperless. So if you apply for a certified copy online with the affidavit that Justice Oak was speaking about, you could be given a digitized copy of that affidavit. If it's in a PIL, I would suppose there should be no issue about giving it to you, the state's affidavit. But that would be one of the ways of doing this, that we fully digitize ourselves, and then there's more accessibility to the public for court records. We hope to have that all in place in the near future.
Thank you.
Thank you very much. Nicole, over to you. It can be taken up offline, I think, because now we have to move on to other aspects of the programming also. Yes. Thank you very much. Yes. Okay. All right. So apparently there's another question that Nicole is just reading out. No, she's handing over the mic.
We have received a question from the member secretary of the Goa State Legal Association.
Mm.
So the question is that there are some disabled people who needs aid to read, which is costly, and the person who cannot afford to purchase this aid. So the question is to both commissioners whether there are any schemes of government to provide such persons with hearing aids, and if yes, then what is the procedure?
Assistive device. I think this is screen reading software that they write.
Acha, acha. So, yeah, okay, 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 okay. Yeah, okay. So, may I know what is the facility required specific? Screen reading software. Actually, recently, an OM has come out that to empower the Divyang employees, right? They need to, the organization, the employer is expected to provide all necessary equipments, that is assistive devices, which would enable them to work equally with others, right? There is a perfect description in that, what all could be the value, how much it could be. So there are clear mandate that every employee who are Divyang should be provided with assistive devices according to the responsibility of the particular employee. He should be equipped, well equipped to compete others or to discharge their duties. So you can very well, if you want, we can share.
Sir, this is 22nd September OM, sir. 22nd
Yeah, this is very well is in available in the public domain as well. We can also share this OM to you for the reference.
Okay, thank you very much, ladies and gentlemen. Nicole, over to you for the further aspects of the programming.
Thank you, dignitaries, Advocate Bajaj, for moderating this session, and thank you to our engaged audience. We now move to a proud moment, the presentation of the Mission Accessibility Annual Awards 2025, recognizing outstanding contributions in promoting accessibility and inclusion. We invite Advocate Turab Chintanwala, currently working at Securities and Exchange Board of India, and Advocate Sarah on stage to announce the awards and present the honors.
For the past 3 years, we at Mission Accessibility have recognized individuals and institutions that are going above and beyond to advance accessibility and empower persons with disabilities. These awards are our small effort to recognize their efforts. This year, we are proud to present these awards in 2 categories. Our first awardee is Miss Khadija Khan, Senior Correspondent at The Print. A lawyer by training, over the past year, Khadija has brought remarkable depth, sensitivity, and consistency to the coverage of disability right issues. She has not only highlighted important disability right cases through right-based lens, but has also gone beyond courtrooms, engaging directly with the petitioners and bringing lived experiences to the forefront. Through her stories, Khadija has reminded all of us the real human stakes involved behind every judgment, every policy, and every act of advocacy. Thank you, Khadija.
May we request Khatija to give her acceptance address, please?
A hello and warm welcome to everyone. It was in the beginning of this year that I was introduced to Rahul and Amar after interviewing them for a story. Now, 10 months later, I can certainly say that this one meeting resulted in more than 20 stories on cases concerning the rights of persons with disabilities. A very noble fight of which I am deeply honored to be a part of. Thank you, Mission Accessibility, for this award and for all the work that you do, for all the good you put out in this world, and for all the lives you have touched and made better. Thank you, Justice Oka. You are one of the finest judges of our time, and your commitment to justice is unflinching and honestly admirable. And finally, a big thank you to Shekhar Gupta, my boss, and Bhadra Sinha, my editor, who have given me this platform at the print to do in-depth stories and ground reports that make a difference. Thank you.
Thank you, Khatija. So for the second award, so friends, as we often talk about Gen Z as that is the future of India, and so we also believe at Mission Accessibility that when it comes to the empowerment of the persons with disability, it is the Gen Z which will take the mission forward. Hence, the best way to encourage and empower the Gen Z is to appreciate those among them who are doing a good job. Hence, for today's since a couple of years, we have an award called Budding Disability Rights Champion. This year's awardee is an author from Gujarat. He has done his bachelor's in art and psychology from Gujarat University. He dabbles in diverse streams from creative activities like poetry and songs to core technical subjects like artificial intelligence and digital accessibility. He has worked with several large companies like Google, Meta, Microsoft, and Apple to make their products and services accessible for persons with disability by conducting thorough accessibility audit reports as also user feedback from community of persons with disability. He also moderates one of the largest communities on WhatsApp of persons with disability consisting of over 700 members. Ladies and gentlemen, please appreciate and acknowledge Mr. Yatin Panchal as the winner of this year's award. Yatin unfortunately could not be there in person. He has joined online. I request Advocate Amritesh Mishra to accept the award on his behalf.
Am I audible to all?
Yatin is giving his acceptance address. Yeah, Yatin.
Yeah, am I audible to all?
Yes, yes, Yatin. Yes.
Yeah, so first of all, very warm welcome to all of you individuals for being here. And when it comes to talk about award, it is something that everyone achieves. And when it comes to talk about accessibility, first of all, thank you so much, Mission Accessibility, for understanding and providing this opportunity to highlight accessibility for everybody's needs. When it comes to talk about reporting things, sometimes it becomes difficult to deal with big companies. Like when you are talking about Google, Apple, Microsoft, and others. Generally, what I used to do is I used to create constructive reports. I used to submit on appropriate channels wherever it used to be required. And then I used to speak with Amar Jain, who has been my friend since 2017. I joined Mission Accessibility in 2023. But yes, sorry, 2024. Apologizing for that. But with Ammar, I had been connected since 2017. So wherever I needed, I took the help of him, and this is how I highlighted issues. Most of the things we have fixed, but yes, there are some issues which are remaining to be fixed. And sometimes companies like Meta and Telegram, they never listen, either if you report through legal or like whatever technicalities are there. But thank you so much again, Mission Accessibility team and others for this opportunity.
Thank you, sir. Over to Nicole for the future program.
A heartiest congratulations to the awardees and thank you to our presenters. We will now commence the presentation of mementos as a token of our gratitude to the esteemed dignitaries present with us today as a gesture of appreciation and respect. May I invite on stage Honorable Principal District Judge Irshad Aga to present a memento to Honorable Justice Abhay Oka. May I invite on stage Honorable D.P. Satwalekar to present a memento to Honorable Justice Valmiki Menezes. May I invite on stage Advocate Rama Rivankar. To present a memento to Senior Advocate Coelho Pereira. I request Professor Savio Falero to present a memento to Advocate Rahul Bajaj. I request Dr. Manoj to present a memento to Shri S. Govindraj. I request Advocate Rama Rivankar to present a memento to Shri Guru Prasad Pavaskar. Sorry, yes. My apologies. I now request the esteemed dignitaries on the dais to kindly take their respective seats in the audience area as we proceed with the next segment of today's program. We are deeply honored by your gracious presence and we thank you for gracing the dais during the initial segment of our program. It is now time for a dynamic and insightful panel discussion on strengthening legal empowerment and access to justice. May I take this opportunity to warmly invite our esteemed panelists to kindly come up on stage and take their seats on the dais. I request the staff to kindly assist our panelists onto stage. I call on stage Senior Advocate S.K. Rungta, Designated Advocate practicing at the Delhi High Court and the Supreme Court, and President of World Blind Union. I call on stage Advocate Kanchan Pamnani, practicing at the Bombay High Court, who has argued cases for persons with disabilities and helped blind students receive admission to physiotherapy courses. I request Mr. Praveen Prakash Ambasta, Deputy Commissioner for Persons with Disabilities, Government of India, who handles grievances on behalf of persons with disabilities and provides justice to them. This discussion will be moderated by Advocate Amar Jain, who I also call on stage. He is the co-founder of Mission Accessibility, He practicing at the Delhi High Court and Supreme Court and is a national awardee by the President of India. Let's listen in as our experts discuss practical strategies, lived realities, and future roadmaps for disability rights in the legal ecosystem.
Thank you, Nicole, for that beautiful comparing. And good evening, ladies and gentlemen. It's an honor, privilege to be with the people on the stage who are mentors for us, who have shown us the vision for the sector. Senior Advocate S.K. Rumta, sir, we have seen him as somebody who has really guided, stood up for the cause every time. We have also seen Sir practicing complicated commercial matters, and his simplicity and the wisdom with which he brings clarity to the matter is amazing. I'm also joined by Advocate Kanchan Pamnani ma'am, who has been my mentor, who has guided me, who has grown me up in becoming a better lawyer for the society. Praveen sir is one such person who has been always there for the sector, and has been very generously helping everybody when in need. So it's a privilege to welcome everybody in this panel. I'll start with my first question to Rumta sir. So you have lawyered, stood up for persons with disabilities uh, for 4 decades now. And in your assessment, so what has the change that you've seen from the times that you started to today? How cases of persons with disabilities have come to courts? And what is the biggest impediment that you see that persons with disabilities face in accessing justice?
Thank you, Amar. And I am privileged to have panelists like Kanchan, who is my professional colleague, very hardworking and very devoted advocate. I have, in the form of a bureaucrat, if I may call him, Deputy Commissioner Praveen Ji. So, coming straight to the question, in the interest of time, I started my practice way back in the year 1982. And honestly, I did not enter into disability advocacy field in terms of legal profession, though I was in the disability advocacy right from my childhood. Until the case with regard to the civil services examination that I filed on behalf of National Federation of Blind. And I will come to this a little later. Now, the question is, as to what do you feel, what has changed from the time when I took up the first disability-related matter and now? The first change that we know of, and it is no matter of secret, that at that time when I filed the first public interest litigation in Supreme Court, there was no law on disability rights. So I had to rely on constitutional provisions. And I'm glad that Honorable Apex Court, in that judgment, Honorable Justice Kuldeep Singh Ji, and his colleague delivered, where it was first declaration of right of persons with visual impairment to hold the office of civil services, including IS, if they are selected. And along the side, they be given priority, preference. And also they be allowed to write the exam in Braille or with the help of scribe. And the government was directed to consider extending reservation in Group A and B as well. As all of you know, I mean, at least those who are working in disability field, that, before the enactment of Disability Act 1995, we did not have the reservation in Group A and B. The reservation was extended only for Group C and D posts, that is lower posts, not at the highest level. So that is the first change that I've experienced. The second is that at that time, it was a new arena, absolutely an arena where nobody has played. It was a field which was never tried. And therefore, I would say it was an advantage. Because when you have something, you start from a clean slate, you have an advantage. Because then you are trying to write as you want to write. And in that pursuit, you have to persuade the court to write in the manner you want the court to write. So that is an advantage. Now we have very good positive case laws. Positive, I would say. I know about the other questions that Amar would ask me. So I am reserving reference to that when I say positive case laws. I would try to compare that with other jurisdictions as well. So that's another change. The third change that we have after Rights of Persons with Disabilities Act, access to justice has been recognized as a right. I remember one day when I was very new in the profession, very young, 27 years of age, I was appearing before one of the honorable district judges in a probate case. In that probate case, the interesting part was that the testator was also blind, beneficiary was also blind, witnesses were also blind.
Wow.
Now, this is a live example I am giving. And the lawyer was also blind. That's another part to it. I would not name the judge. She said that what is your locus to produce attesting witnesses who are blind, who cannot read? He said, then what is your locus to appear as an advocate because you are blind? How did you accept wakalatnama without having verified that client has really signed it or not? I tried to answer. At that time, I was young. I was angry as well. But, other colleagues in the court who were senior, who were present, came by my side and tried to rescue the situation from being worsened. Then the judge said, I am going to decide it today. I said, no, give me some time. Let me lay my hand. And that's one of the strategy that you always work when you see the courts. I know the judges are here, but we use, as all advocates who are present here would agree with me, at times we use this strategy of taking adjournments on one count or the other if the court is not with you. So that strategy I employed at that time. I am sharing this to show where the mindset was at that time. And now, what is the mindset? The mindset is all positive, proactive. You saw Honorable Judge of the High Court here, then and there committing various things when the problems were being faced. And compare it with that illustration that I gave to you. So we have traveled thus far and for good with very solid grounds. So that is the other thing that has changed. The third thing which has changed for the present and which probably is challenging for us, and that is that when we talk of disability, we are trying to treat everything into it and try to dilute even at times with respect to some of the judgments also, when the Honorable Apex Court has said that, look, you cannot restrict the benefit to persons with benchmark disabilities only. You have to go down even. Could be a right approach in certain areas, but could not be a right approach in certain others. For instance, reservation. If you give that flexible approach to the statutory scheme of reservation, you see what is happening today? Fake disability certification, and by virtue of this menace, people who are severely disabled are often ignored, and by way of fake disability certification, people enter into the services by taking benefit fraudulently of our quota system. So that is a serious matter that probably both judiciary and commissioners present here and the government functionaries will have to take a call. And I had been suggesting that yes, at the stage of selection, you include everybody on the basis of disability certificate. But before giving appointment, you have a double disability check from another disability board, which has not given or issued that the disability certificate. So this is an area which I think which is to me a negative kind of development that probably we will have to be aware of, and we will have to guard against it. So these are some few. And then last, I know Kanchan would also agree, because in the morning she also has voiced that at that time there was no technology when we started. Now there is technology, there is the digitalization. At that time we had to depend on going to the inspection rooms and looking at the file, taking somebody with us as a blind lawyer to look for the part of the file that we want to inspect, and so on and so forth. Thank you.
Thank you for that insightful answer, sir. There is a lot to learn from that. I'll now move to Kanchan ma'am. Kanchan ma'am, you have been a lawyer. You have also practiced in the area of testamentary and non-testamentary matters. You have also taken up disability rights issues, including access to banking facilities and many more. Ma'am, you have been a lawyer and a woman with a disability. How has that been a challenge, and how have you navigated that part of your profession?
So I would be one of those lucky ones that has not had a problem being a woman with disability. In fact, I think it's been an advantage to me, okay? Because I can perceive being blind and being a woman, I think I have a little more instinctive reactions to situations. There are people with disability who have more issues. I can say that for sure. But I've been pretty lucky not to, at least those don't come up. The regular issues come up. The road from my office to the Bombay High Court is about 17 minutes if I could walk straight. But if I have to go through puddles and ditches, there's nothing I can do about it. My heels will go in. If I was if I didn't want to wear heels, then I wouldn't have those problems. But there are problems. Those are regular problems of every lawyer or everybody who walks on that road to the High Court. There are problems of pushing into the lift. There are problems of ramps now coming up. There are issues like in courts, there are not enough chairs. There are outside the courtrooms, Justice Oak's courtroom 13 had no benches outside it. So there are tons of lawyers standing out there and trying to get up those 4 steps without holding on to something to get into the building. So those are problems that everybody faces. I have seen over the years, in the last 35 years, I've been at the Bombay High Court. A lot of people are doing, lots of lawyers are doing matters of disability now. And lots of litigants are now willing to pay those lawyers. But when it comes to going to a lawyer with a disability case, they all still thinking twice about it. So for those who are there, who are practicing, is good. I have a lot of non-disability work now, and I do a lot of it. And there's no problem whatsoever. If you come clean on your disability and you're there, you have your technology backing you, and you have the knowledge of the area you want to work in, clients will come, and there is no difficulty on that one. So that commercial practice is good there. So a lot of non-disabled lawyers are doing disability work. A lot of disabled lawyers are doing non-disabled work. So that's a lot of change over the last 30 plus years that we have seen.
Thank you, ma'am, for giving that perspective to the audience. Actually, this question I also have for Rumta sir, and before I come to Praveen sir for a question. Rumta sir has been not only a disability rights lawyer, but has been a commercial lawyer as well. And so very often it happens is that if people see lawyers with disabilities, they would think that lawyers with disabilities are good for doing disability rights cases, and you're pigeonholed in that entire situation. They don't treat you as a conventional lawyer who can deliver mainstream legal services. But you have done that exceedingly well. People recognize your contribution in commercial law as well. How have you really balanced between the both, and what tips would you give to young lawyers like us to branch outside of disability rights as lawyers?
Thank you, Amar. This is really a very interesting question, and for our young lawyers with disabilities, I would say 2 things to it. First of all, there is no straight answer or straight formula to suggest. But I had the advantage of entering into the profession by using mainstream cases. And you know what I did? When I joined the profession, I waited for some time for the first brief to take. And it was not because the briefs were not coming to me. When the day I enrolled myself, I had 2 clients who wanted the cases to be filed, their cases to be filed through me. But those cases were, I was not sure whether I would get them relief. I refused. Why I refused? Because had I taken those cases that day, and if I was not sure that I would be getting relief for them, how could I persuade the court to give relief? Therefore, had I taken them and had I failed, which I would have failed, I think I would have seen my last day in the profession, and I would not have been what I am today. And it was a wait of 3 months. It requires a lot of patience for the beginners, I would say. And for us, it is more than the patience that is required for a non-disabled lawyer. But after 3 months, I got cases relating to landless Harijans who were though given allotment of land, but were not given possession under 20-point program. And all those lands were encroached upon by Jamidars, continued to be encroached upon. And those Harijans had lost up to the stage of Development Commission, that is the last revenue court, highest revenue court. The next step was only High Court and then Supreme Court, of course. At that stage, I got those 7 cases. And I remember my maiden appearance was before Justice Ward. And people who know Justice Ward, he always came prepared to the court. Before advocate would open, he would start questioning. And as soon as I stood up, he started bombarding with the questions. I started answering them immediately because I went all prepared, though I was running 102 fever. I went all because I knew either I will make it into the profession or I will unmake myself in the profession. I will fail. That was like a examinee preparing for exam. So at the end, I was so lucky that I got the relief that I wanted. And he gave me all the appreciation, even asked the entire lawyers sitting in the courtroom to stand when I was leaving the room, courtroom after getting the relief. Now, that made me, or that created a credibility in me for the clients, and it was so spread. And I must tell you one thing, that if you do something in favor of illiterate people, rural people, they are best ambassadors for your credibility. I am telling you this. I have experienced this. And then I did not have any looking back. Now, you are right. There is a lot of competition. And people, I have heard people saying that if we have choices of non-disabled lawyers, why should we take that risk? That probably is the question that we need to answer, and we cannot answer it. We can only answer it through our abilities, through our performances, through our actions. And now, for our young lawyers with disabilities, even visually impaired lawyers, I think there are no limits. You don't have challenges of inaccessibility of the system. You don't have challenges of inaccessibility of the material. You don't have challenges of other hostile environment, at least related to legal profession. Yes.
What an answer. Patience, perseverance, and making sure that we serve everybody, even the lowest strata of the society. Thank you, sir, for that insightful answer again. Praveen, sir, you have been with CCPD in 2006 to 2009, and you are also now with CCPD since 2023, and you're here till 2026. What is the change that you have seen in the functioning of CCPD and in overall grievance resolution when it comes to disability rights matters?
Thank you, Amarji. I'm slightly newcomer, even if it is 2006, because the two people sitting to my left, they've been doing it for a decade or more than that before I actually joined CCPD. Rungta ji started in 1982, and Kanchan ma'am, I remember from the, and you were responsible for the CBSE guidelines for amnesty scribe, even before there was a pan-India guideline. Bombay High Court actually
Yes,
gave that order. You were the one, and I remember the meetings. I was facilitating that meeting as a young officer then. And so what have changed from 2006? One is, of course, the number of complaints. It has grown like anything. That is number one. Number two, the types of complaint. Just last week, Honorable Commissioner Dr. Govind Raj was hearing a matter, and a person said a particular brand, a particular model of a mobile phone is not accessible. So the commissioner asked, how are you aggrieved by that? There are thousands of other brands, but he said, but I have already bought this. So, so therefore, this needs to be accessible. So earlier, the complaints were quite, mostly for tangible benefits, but now we are also having complaints for dignity. So many people have filed, for example, against railway, a complaint came that you cannot call us mentally retarded. So remove that terminology from the certification. And so that case was heard. 3 hearings were conducted, and in May 2025, that was finally culminated as agreement by the railway to remove that terminology. So for those issues also, people have started coming up. And also on accessibility, earlier there used to be very few cases. Now we have lots of cases. We have more than 200 cases merely on accessibility. And can I say that most of these courtesy two advocates, Amar Jain and Rahul uh, Bajaj. So these are the yeah, but of course we have others as well about digital platform and also physical accessibility. So those cases also have started coming up. So that is a change. And also that time it was all paper, paper and paper. I mean, now there is absolute paperless office, and the proceedings are being undertaken through the portal. So ccpdcourt.gov.in, that is the name of the portal. And from registration of the complaint till disposal and ATR monitoring, it is being done through digital platform. This is now 2 years old story from September 2023, and in January 2024 we completely switched over to the digital platform. So ye change hearing during COVID, it started totally online, and now it is being done in a hybrid mode. So anybody who wants to join. So these are some of the changes that I would say. And uh, yeah, so transfer matters are now taking 28% of the total cases. Before us, it was not there like this earlier, okay, because there was no such provision in the act about transfer posting of persons with disabilities. So that is one thing. Also, penalties were not there earlier. There was no provision for penalty in the or offenses in the previous act, PWD Act 1995. In the new act, we have a whole chapter on penalty. So these are some of the paradigm shifts which have taken place. Thank you.
Thank you so much, sir. The Office of CCPD and state commissioners have been very, very facilitative in providing speedy justice to persons with disabilities. And your commitment is really can be seen by people who witness the kind of work that the office does. So thank you for that. I'll turn again to Roongta, sir. I wish this panel can go on and on. There is so much to learn. Uh, Roongta, sir, you have seen multiple jurisdictions and you have seen disability rights in various jurisdictions. How has been your experience in terms of if you compare those jurisdictions versus India's disability rights, and what are our strengths and weaknesses, if we could learn from you on that?
Thank you, Amar. I have the privilege of now leading World Blind Union as its elected president now, very recently. But before that, I, in my capacity as president of Asian Blind Union, have had the opportunity of interacting, participating in various international discourses and meetings with other stakeholders, other disability groups and organizations. I would say that first of all, if you look at the enactments in different jurisdictions, we have adopted mixed approach in our enactment of Rights of Persons with Disabilities Act. We have a provision for affirmative actions. I mean, concept of positive discrimination. We have also the concept of reasonable accommodation. We have, for instance, for employment, we have quota system. In US, in other certain jurisdictions which are more aligned to US system, they don't have a quota system. They have a reasonable accommodation principle. And reasonable accommodation principle has come for adjudication before the courts in US and also those jurisdictions. And if you look at those adjudications, you will find that they are not very much tilted towards the protection of rights of persons with disabilities. They are more tilted, if you try to analyze the overall jurisprudence, they are more tilted towards employers, towards corporates, while deciding whether it would be a disproportionate burden or not. But compare it with our recent judgments. Be it Vikash Kumar's judgment, be it that suo motu writ petition on judicial officers issue. How well our apex court has ruled while interpreting reasonable accommodation. Our apex court has gone to the extent of saying that if you take a policy decision unmindful of the principle of reasonable accommodation, that is illegal. That is void ab initio. The word used is innocent of the principle of reasonable accommodation. Anything done, any policy made, innocent of reasonable accommodation. The recent example you see, and I'm fighting this on that principle and on that basis of the judgment of Honorable Apex Court. Recent revised guidelines of scribe, where they have overnight one morning decided, look, you have to independently write exam and use technology. Where is the preparedness? Where are you preparing us? Are you providing computer training to children with blindness at these special schools, at the school level? If you are giving training, are you making the hardware and software available to them at affordable cost? And so on and so forth. So this was unmindful of principle of reasonable accommodation. Another important that part, and that probably is in sync with other jurisdictions as well, that you don't decide anything without consulting persons with disabilities. Nothing about us without us. That is the philosophy. And that is the inbuilt philosophy of Rights of Persons with Disabilities Act and all other acts in different jurisdictions. And in fact, UNCRPD. So now, quota system, for instance, in jobs is in Japan also, Germany also. But there what is happening? Our quota system is more or less better, and its implementation is better than Germany and Japan. Why? Because there we see that corporates and others who have to provide that quota in jobs for persons with disabilities would prefer paying fine and done away with it. Here it's good that we have not adopted that path. It was suggested once, though, when this RPWD Act was being formulated. In one of the original bills, draft of the bills, it was included, in fact. I opposed it, and many of our colleagues opposed it. And I'm glad that it did not get included into it, incorporated into it. So that way, to summarize, I would say that our positive jurisprudence, which has evolved on the interpretation of various provisions of the Act, Rights of Persons with Disabilities Act, and even Disability Act of 1995. Because if you look at the employment, the edifice of positive case law has been laid there in the judgments of Honorable Apex Court, particularly the judgment on civil services way back in 90s. Then also, if one remembers, before the enactment, in 1993, when this Mandal Commission was brought into force, our reservation in Group C and D, which was available at that time, was sought to be abolished and merged into the caste-based reservation. And we again, on behalf of National Federation of Blind, filed an intervenor application. And when the court came down heavily on the government of India and asked Soli Surabji, who was AG at that time appearing for the government, that if you don't restore this reservation for persons with disabilities, we will stay the entire notification. Next date, our prayer was accepted, and then it was restored. You can check this. This is on record. So that's how Supreme Court, High Courts have come to our rescue and protected our rights and tried to ensure implementation of every provision of the Act which has come before them for adjudication. And I would like to appreciate the positive attitude and positive outlook shown and reflected in all those historic judgments. Thank you.
Thank you, sir. In the interest of time, I would request each panelist to give their closing remarks on future vision. What could we be doing better? What is it that we can where we can kind of take the sector and so on. So maybe Kanchan ma'am first.
Yes, okay. Thank you. I see a lot of litigation ahead of us, but I also see a lot of discussion and framing of guidelines, etc., which is sitting down, mediating, talking to people, understanding the issues fully. Everything does not need to go to court, but a lot of things will go to court. A lot of issues will go to court. A lot of lawyers who know some disability will argue, Ada kacha, ada pakka. We have to be very careful of that scenario because we don't want to lose what we have got. And we do not want people to get in things that we do not require or, to narrow down our lives. We want to expand our reach. We do not want to narrow them down. So the future looks like a lot of work for the CCPD, a lot of work for the high courts, a lot of accessibility, reasonable accommodation with reasonableness coming in, not anything and everything under the sun, but reasonableness. And a lot of people are going to be more disabled than they are today. That is a reality that we see. We see a lot of multiple disabilities in the young, and we see a lot of senior citizens needing assistance and who may not get certified, but are going to need a lot of facilities and services. So I think there is a trend, a movement in the sector, and that's something we have to accept. So a future for the next at least 25, 30 years is going to look like that. But I may be wrong, but I think this is where I see it going. Multiple disabilities at the younger levels and the senior citizens coming in. And all of us trying to push ahead. Thank you.
Thank you, ma'am. So cross collaboration is an important lesson learned from this answer. If I could move to Rungta sir and then to Praveen sir, please.
Thank you, Amar. I will be very quick. I think future is both challenging, but at the same time promising. When I say challenging, we will have to work now after having made our journey thus far on streamlining the procedures, on the manner in which different aspects of the Disability Act are to be implemented, because implementation is the biggest weak part of our journey so far. The second that I would like to say that why it is challenging is the competing demands, both among the disability groups itself, because of the increase in the number or categories of disabilities in the Act, 21 in number, but because also of their diverse needs. Though we have put disability in one compartment, but that compartment needs cubicles. Cubicles in terms of the specific needs. Unless we frame policies which also ensure that cubicles in this big compartment are also made to serve specific disability needs, I think we will not reach the desired goal. And third and last, but not the least, is that we must try to develop a consensus approach among the DPOs while dealing with a particular issue or challenge that comes our way, and try to form a cohesive strategy rather than speaking in different voices. Thank you.
Very, very insightful, sir. I think uniting everybody is more important than to achieve uniformity. Praveen sir, your closing remarks, please.
Thank you, Amar. But I mean, with due respect and humility, I would like to set the record, also state about what Mr. Rungta had to say about the new guidelines. One is to say that it is done overnight is not correct. Any letter will be issued on a particular date, but 2 years time has been given to stop the own scribe. It is not implemented from the next day. Second is, technology has been preferred. You yourself has pointed out about the increase in the number of fake certifications, and just imagine these guidelines are only for competitive examination, not for academic school college examination. Just imagine a person getting 1/3 of the time over and above other competitors when he is not deserving candidate for that. What kind of a havoc this system can create? So therefore, please see from the prism of reforms and also guide us where we have gone wrong. Yeah, I mean, many persons with disabilities, visual impaired persons, have given us very good feedback about the new guidelines also. I have to speak this because I was part of the consultation process, although I'm from CCPD, not having the brief of the department, but still I would like to make the record straight. That is one thing. Second is, what I feel, I mean, I'm a very small frog, in the whole system, but what I feel is that a lot of awareness is required to be created. A certificate which says one arm affected, can one arm affected person can be of 4 types, but the UDID will only say one arm affected. A person with one amputated arm also is a one arm affected. A person having a polio affected arm is also a one arm affected. A person having just muscular weakness and cannot use the arm is also one arm affected. A person who has a deformity in the arm, underdeveloped arm, is also one arm affected. All these 4 categories will have different requirement, different needs. So even the same subcategory of disability has so much of diversity. What to talk about the needs of a hearing impaired person vis-a-vis the need of a locomotor or visual impaired person. So that kind of awareness is not seeping through in the whole system. I'm not even talking about the people. I'm talking about the I mean, the professionals who are using these laws, including at government and non-governmental level. So वो awareness लाने की ज़रूरत है. एक और बात है जो मुझे बहुत शिद्दत से मैं फील करता हूँ वो ये है कि अभी भी वी आर टॉकिंग अबाउट reservation in employment from the prism of 16.4 constitution, article 16.4, but it is not 16.4. I mean, time and again Supreme Court has said that reservation for persons with disabilities under 16.1. 16.1 doesn't talk about inadequacy of representation or backward classes. 16.1 talks about equal opportunity. So this is equalization of opportunity in public employment. That being the case, why nominations like government council or notary? A little while back, Kanchan ma'am was talking to me about notary advertising. Why on those things the representation is not being ensured is also something of concern. I just took the legal side or a judicial side as an example. It is happening all across. Wherever there are job opportunities based on nominations, persons with disabilities are not being considered at all. So these are some of the concerns that we have. And lastly, I would like to say that we are trying to be more sensitive, interacting with persons with disabilities, every player in the sector, and trying to be more sensitive, trying to create sensitivity within our fellow officers and all. At the same time, we would like also the sector to be sensitive towards the ignorance that we have. Sir, you have more than 40 years of career in disability law, sir. I may be slightly older than 43 years. That is your experience. So I would definitely have to learn from you, sir. So please also understand that we may be uninitiated, but we do not have ill intention. We are always there. Everyone is there to support the cause. We need to work, all of us, as a united network. We need to work for each other, stand for each other. Thank you very much.
Thank you, sir. Unity is the key. And with this, we bring this panel discussion to a close. Maybe very briefly, if there is a question that somebody wants to ask, one or two questions, maybe we can take and we can end because we are running short of time. Are there questions from the audience?
So, I'm a deaf person. I would like to ask a question. For example, we talk about the reservation of 4%. And in 4% reservation for category A, B, C, D, we have different categories. And if there is a deaf person joining for a D group post, they give the exam for promotion from D to C. So when we talk about the reservation we have for minorities, for SC, ST, and OBC, and they have the vacancy, like they have the different reservation for them. For exam, if the person with disabilities are appearing for the promotion exam, for B group, from D to C or from C to B, they're giving the exams. If I have not applied for it and still the seat is vacant over there, the reservation, the seat is reserved. For the next year, if I am giving the exam for the promotion part, and the last year the seat was still vacant over there. In the some government setup, I have seen that they merge that seat to the minorities and they don't give it to the person with disabilities. So how we can solve that situation?
Anyone from the panel?
Would like to answer?
No, anybody.
Okay. This is in fact the action that you are suggesting that has taken place. If at all somebody does that, it is all illegal because the provision is very clear that supposing you have advertised it for hearing impaired, reserved, be it direct recruitment or promotion, And in that selection process, you don't get that category of disability. It has to be carried forward for that category of disability itself. Leave aside, it can't be de-reserved, it can't be given to anyone other than the same category of disability in the next recruitment. And if in the next recruitment also, if you don't have anyone from that category, then next recruitment you will interchange it with other category of disability, not with non-disabled. So that's the law. But you are right, it is being violated. It is being violated, no doubt about it. Because they are not maintaining vacancy-based roster properly. I can guarantee if Chief Commissioner for Persons with Disabilities can take this initiative of calling for the vacancy-based roster from all Government of India departments, and so can the state commissioners do, then you will come to know the hard reality that it is not being maintained, and they are now doing it post-based as opposed the judgment of the Honorable Apex Court.
Thank you, sir.
Just 1 second, because CCPD name has come, I have to defend.
Sure, sure, sir.
No, not defend. Only thing is that we are doing it already. And whenever there is a case, we are calling it, we are seeing it, but we cannot call for the whole of India because that bandwidth simply we do not have. It will not be possible, practical. But whenever somebody files a complaint, we are calling for the records and checking it and telling them in our orders. If you care to read our orders on the website, you will find any case related to reservation. You will find we are finding the status and giving recommendations accordingly. And what sir says is absolutely right. Section 34 does not allow any sidestepping. I don't know from where you got this minority reservation or shifting from PWD to minority. I have not heard it. I have not heard it.
Thank you so much. With do we
No, somebody else.
we
Somebody else.
My question is to Kanchanman and Rungta, sir. This, no matter what the law says, eventually there's some discretion available to judges, and in a lot of judgments we also see there's a little bit of charity approach and that kind of language that comes in. How do we as lawyers with disabilities, with a very visible disability, ensure that we keep the law separate from charity, and how do we ensure that we also get the outcome that we want, but also ensure that the jurisprudence is set in the right direction?
Okay. See, one of the things that I have noticed is the wordings they use, okay? Suffer from blindness, suffer from leprosy, suffer from this. So you try to tell the judges that, you try to correct them there and then if you can, in the court itself. But a lot of judges do not want to listen. They do not, when they're dictating the judgments, they're actually using the wrong words there. You're right out there, they are. One way of looking at it, years ago when we were doing the copyright work for the copyright change, Sushma Swaraj at that time in Parliament called us Deen Dukhyare. I was appalled, okay, because I was watching it on TV and I'm like, Deen Dukhyare mein और हमारे लोग नहीं कभी नहीं पर फिर भी हमारा law change हो गया because of that. Okay, she actually pushed it ahead and we got the copyright change because of that. So sometimes you have to balance the two. I'm not saying we don't want charity. I don't want to be called a Dindukare, and none of us are. But कभी कभी बोल देते हैं लोग और हमें सुनना पड़ता है. कभी आंचल जब भी हम कोर्ट में हैं, we have to see the judges say a lot of things. They have to be educated offline, off the courts. Not inside the court all the time. We cannot correct them there all the time. We have to have our strength to have when we are arguing, we should not falter. Okay, we should not ask for concessions. We should ourselves go forward and argue it correctly, like other lawyers would. So don't ask for a concession there. So once we don't ask for concession, they will treat you with the respect, and it takes time. It builds up with time. Okay.
Thank you, ma'am.
Rungta, sir, would you like to add anything?
No, it's okay.
Thank you so much, ladies and gentlemen, for being here. And it was a sheer privilege to moderate this discussion with luminaries like these. Thank you so much. I hand it over back to Nicole.
Thank you to all our esteemed panelists for this enriching discussion. I would now kindly request the esteemed panelists on the dais to kindly take their respective seats in the audience area. Also requesting the designated staff to kindly assist the panelists to their respective seats. Moving on to our next segment, we now invite Advocate Anchal Bateja, Research Fellow with the Center for Legal Policy and Consultant, Mission Accessibility, to share her personal journey of practicing law in 2025. Her experiences reflect courage, resilience, and the possibilities that accessibility unlocks. The mic is running fine.
Good evening, everybody. The design of this session was actually very interesting because before me, whoever spoke, everyone belonged to the 1995 generation. I belong to the RPWD generation because I was rendered blind about 2 months before RPWD Act was passed. So I'm literally and metaphorically the RPWD generation as Justice Chandrachud imagines in Vikash Kumar versus UPSC. So I'd been asked to speak on lawyering in 2025 with a disability. I learned the most important lesson on disability law not through a disability lawyer actually, but during an interaction with my history professor. I was very anxious before my placements and I called her up and I told her, what would I do if corporates don't hire me because of my disability? She said, not everything that goes wrong with you is because of your disability. For example, you got a B+ in history not because you had a disability. Maybe your project was not as good. So that's where I learned that not everything that went wrong in my life was because of a disability. And this is the first point that I want to make as a young lawyer who is starting out her career, that, not every mistake that a person with disability would make on the bar, on the bench, off the bar, off the bench, it won't be because of the disability. It would probably be because they are a fresher. And that's what Kanchan ma'am and Rungta sir also stressed upon. It takes time, it takes experience. And while that happens, while a fresher is navigating the challenges in the courtroom, outside of the courtroom, and their disability, it requires a lot of patience, not only on the part of the lawyer who is dealing with those challenges, but also with the scaffolding that is provided to them. This patience may come up in form of the infrastructural accessibility that a lawyer may need in terms of making courts accessible, making websites accessible, ensuring that there are audio captures, ensuring that the filing is done in an accessible manner. It may require attitudinal accessibility also. Sometimes judges being patient with lawyers with disabilities when they are struggling to find a page number while arguing. It may also come up in the form of digital accessibility in a lot of ways. So that is on the aspect of being patient with lawyers with disabilities, and also lawyers with disabilities being patient while they are navigating the first few years of their profession before they learn how to deal with all the accessibility challenges that exist. And I think it's a very steep learning curve. The second point that I want to make is that lawyering just doesn't happen inside the courts, as a lot of us stressed upon, and also Kanchan ma'am did. It also happens outside of courtrooms. That's the kind of work, for example, we are doing at Vidhi. We've partnered with one implementational organization, and we are helping schools, government schools, to understand how reasonable accommodation can be implemented on ground. Because Section 16 stops at saying that reasonable accommodation must be provided. But when you take the legislation to a grassroots worker, they won't understand what it is. So that's where you require something more than just a legislation. And that's a very interesting journey. Mr. Rongta sir emphasized on how he argued with the Constitution for disability rights, and now the generation of Rahul and Amar and I, we have a very long and detailed RPWD Act. Now, maybe the next step is to get more detailed guidelines, SOPs in every school, in every college, in every institution, be it private or government, that says accessibility is mandatory. Uh, for example, that's the kind of work that I've also been doing with national law universities, for example. This year, I'm happy to share with all of you that from July onwards, I have spoken to students across 8 national law universities, which has spanned to about 1,000 students and 50 faculty members, where we've gone and told them what reasonable accommodation really is. Reasonable accommodation is just not a principle on paper. It ought to be substantive, it ought to be intersectional, so that we recognize that within the community, there might also be disabled people who are queer, who belong to different caste communities, who belong to different genders, who belong to different class communities. The concerns of persons with disabilities might be very different basis on what kind of background they come from. So, as a lawyer with disability, where lawyering spans courts, classrooms, and at the grassroots level, I would request you all, in whatever capacity you're sitting here, as lawyers, as policymakers, as judges, as bureaucrats, to think of disability inclusion in your day-to-day practice. It doesn't matter whether you're working in disability or not. If you're designing a tax code, if you're designing a municipal code, if you're making an Instagram reel, think of disability inclusion, and that is what will make lawyering with disability, for disability, and by disabled people easier. Thank you.
Thank you, Anchal, for sharing your inspiring journey with us. Now we have our very own Amit Birje, legal assistant at the Goa State Legal Services, to share his journey with us.
Hello and good evening to all. Yeah. Hello and good evening to all. To introduce myself, I am Advocate Amit Birje, legal assistant at High Court Legal Services and High Court Legal Services Committee, Goa State Legal Services Authority, High Court of Bombay at Goa. So to introduce, basically with my studies, I have completed my BLLB in 2023. After that, I am master's in criminal law. And as I joined the office, I would like to means share the experience related to, first of all, after me, if any person with disability or any other normal student willing to be at this stage, then I suggest that the person should have good knowledge of law, including the local laws, as the each client or the person appearing in the office is different, the cases are different, also the clients are vulnerable. So what I suggest is you should have good knowledge of law, as there is also, you have no senior who can help you out at that moment of time, because all the clients are in the hurry. And what I have come across, the clients that all want to appear at the high court, and all the people want to file a writ petition. So you should be calm, you should have proper knowledge so that you can explain them properly, and tell them that so and so matter can be done at so and so stage, and there is no need of coming to the High Court and making pressure and having multiple filings at the High Court. Secondly, I would also like to add to those senior citizens and also persons with disability that if they can't go and access legal services, then they should call upon the helpline number, that is 15100. And I request is to listen the entire menu and don't go directly to the emergency option, because we have Taluka Legal Services Authority, also we have District Legal Services Authority, and then we have is Goa State Legal Services Authority, accordingly all the State Legal Services Authority. So if you choose emergency option, it directly connects to the High Court. So I suggest you to listen the entire menu. You know your problem very well. So choose your authority and then go with the same. So that is the best option, I feel. You can connect from everywhere, from your home, your office, and from all the these things. So then you can connect directly and take the advice whatever you want. Lastly, I would like to add to the statement given by the Sir Justice Valmiki Menezes regarding the paperless filings. Uh, the in our e-seva kendra, the scanner which we have is the best scanner currently, I feel, because after scanning all the documents, it directly converts the content into OCR. The OCR is best, and the people with vision impairment or visually impaired don't know the importance of OCR. So if that scanner or better scanner than that is placed in the district level courts or the taluka level courts, then such scanners can be helpful for future disability advocates or the clients on or other peoples. So that I would like to add. And secondly, I would like to conclude by stating that the persons with disability who are there, I would like to say that don't lose your hope, don't let yourself down. The only option we have in our hand is our study. So do study hard, do work on your skills, don't lose your hope. And as Justice D.Y. Chandrachud rightly said, study. So please study, achieve your goals, and don't let yourself down. And if you are in Goa, we have our helpline, as I told you, 15100. You can call upon that. If you're connected to emergency option, then I'm available from 10 to 5. You can connect with me and I will try my best to guide you. Similarly, in all the states, the same helpline works. So you can call upon and take the help from all the legal aid services. So that's all from my side. Thank you so much. And if you have any doubts related to legal aid services, you can contact me and you can ask questions related to Goa. Thank you so much.
Thank you, Amit, for sharing your inspiring journey with us. Stories like yours moves the conversation forward. In this final segment, we explore how disability rights can be embedded beyond courtrooms into culture, education, and media. Presenting this session, we have Ayushmita Samal, Consultant Grants and Institution Building, Mission Accessibility, and Tanvi Mohandas, Legal and Compliance Council, Billion Readers Initiative. We first have Ayushmita Samal, who will be presenting by video conferencing for us today. Over to you, Ayushmita Samal.
Hi, I wonder if I'm audible and visible properly.
Yes. Yes.
I would just like to check with the sign language interpreter also if they can hear me well. You can just give a thumbs up if that's the case. Okay, I assume that I'm audible. Okay, I'm not really sure what the screen system is like at the venue. I apologize. First of all, I couldn't be there in person. Everything was planned, but there was an emergency on my end, which is why I couldn't travel yesterday like originally planned. But I hope that this is still a little meaningful for those who are joining in person today. I wish I could be there and see you guys, but it is what it is, I guess. I will share my screen. And again, I'm not 100% sure if you would be able to see everything, but I would still go ahead and do it. Yeah. So I quickly created a small presentation because I thought that it'll be great if you can also look at some things while I talk about it, given that I'm not there in person. Right. So I'll try to keep it as short as possible because we are already running behind time. But basically, the project that Mission Accessibility has been undertaking and the one that I'll be presenting today is that of integrating disability justice into the NCRT school curriculum. Starting with some of our goals, we wanted to introduce the concept of social justice, intersectionality, diversity, and fairness from an early age. This conversation happened earlier this year where we were figuring out which curriculum to tap into because our we are working with the Office of the Chief Commissioner of Persons with Disabilities on this project, and we were wondering together what will be the best way to take it forward. And we realized that it will be great if we start early on. And that is why we tapped into the school curriculum of NCRT. We also wanted to catalyze a collaborative dialogue amongst stakeholders on the realistic and practical ways in which disability justice can be integrated into the school curriculum. I'm being very intentional when I use words like realistic and practical, and that is something that I'll come to at a later point. We also wanted to highlight to what extent disability justice is currently a part of the curriculum, what has changed in the last few years, and what remains to be done. I will highlight at this point that the goal was not inclusive education. We do recognize its importance and the importance of mainstreaming it as well. But our goal was not that of inclusive education. Our goal was more in line with the National Education Policy of 2020, which advocates for mainstreaming of learners with disabilities. And we figured out that, well, we thought that if we are working towards a world where learners with disabilities are working alongside those with able-bodied learners, we need a system that is devoid of systemic barriers, stigma, and everything that inhibits a learner with disability from being in school. So we wanted to look at the attitudinal side of things, and that's why we tapped into the school curriculum. And how we did that is, first of all, we did a review of all the books that NCRT has. All the books are in fact available online on their website from classes 1 to 10, where we looked at each class, each subject, and each chapter that these books had. And we tried to identify, okay, to what extent disability or disability justice is featured in these books. The output that came out of this endeavor was an analysis document that we have shared with NCRT, and I'll be happy to share it with the larger community as well, which basically outlines our findings as well as our comments as to what already exists and what can be improved. We have also so far conducted 2 joint workshops with the Office of CCPD, with Praveen sir's assistance, in fact, where we have invited sector experts, educators, researchers, folks from the NCRT and persons with disabilities to have a collaborative discussion about the findings, about the books itself, about their journeys, their knowledge. And because we wanted to not restrict ourselves to a research study per se, we wanted to find a step forward. The outcome that came out of these 2 workshops was a set of 3 steps that we're going to take in the next couple of months, which I'll get to at a later point. So our approach has been that of review plus dialogue and identification of actionable incremental changes in a nutshell. What has been really great in this journey is that disability in the NCRT books is not what it was when I was in school or when all of us were in school, maybe. There is a lot that has already been done. There's a lot of content already in these books. There is a lot of representation, and representation is consistent across classes and subjects. The very first instance where disability comes up is in class 1 in an English book, where a person who's using a wheelchair is pictorially represented in the book. And from there, the books have taken an incremental approach where in each class, in each subject, there's a little more, there's a little more. And by classes 9th and 10th, we talk about a little bit of the policy side of things also. On that note, disability related benefits are also discussed in the later classes. I think in class 9th is where disability related reservations and disability benefits have been discussed. And persons with disabilities are active figures in the narrative-based chapters. So, for example, if there's an English book or a Hindi book which takes a storytelling approach, there are characters with disabilities who are telling their stories. People are reading their stories. So there's a lot of hands-on approach. What, however, in our findings and our analysis was a little not so great was that there is a little bit of inconsistency in the way disability is being described and being talked about. For instance, there continues to be words such as handicapped, or in Hindi, Viklang, which are being used. Apahish, not Viklang, Apahish, that are being used, which is not consistent with the UNCRPD, to which we are a signatory to, or the human rights model of disability. The representation of disability is also largely restricted to visual impairment, locomotor disabilities, and hearing impairment. And we did have a discussion on this point during our workshops, where people told us that it's easier to talk about certain disabilities than there are than others. Somebody was saying in a previous session that we have to ensure that we work for each and every disability. But the issue that a lot of the writers, or a lot of the writers or the illustrators are running into in the case of NCERT books is that it's easier to represent a person who uses a wheelchair and is a person with locomotor disabilities, because you can draw a wheelchair, you can draw a person sitting on a wheelchair, you can draw a person using a cane, wearing tinted sunglasses, tinted glasses, which are very obviously disabled narratives or representations, right? But it is harder to represent disabilities such as hemophilia or sickle cell disease or autism, which is why the representation also is dwindling. So those three disabilities that I've mentioned are the ones that get the most prominence in these books. And the way disability is discussed in these books takes a little bit of a binary approach, where we are either looking at persons with disabilities as object of pity, who need help, who need empathy, who need support, or sources of inspiration. There's a narrative as to if that person can, who is a person with disability, why can't I? So that binary becomes a little clearer when you go through each and every book for a couple of classes. And the human nature of disability, the humane angle to disability is a little bit missing. Those were some of our findings. Talking a little bit about our engagement with NCERT so far, like I said, we have conducted these workshops where we have had participation from the Department of Education of Groups with Special Needs and the Central Institute of Educational Technology. And we have identified 3 concrete steps forward. Number 1, right now we have only reviewed the books that are student-facing. But we also realize that these books are ultimately being used by teachers in classrooms to teach. So what we're going to be doing next is picking up the teacher guides that are available. Some are online, some are not, alongside these books to identify best practices and scopes of improvement, to make sure that our comments, our feedback, our analysis are two-pronged, not just limited to the books that the children have, but also the teacher guides that the teacher uses. Second is the preparation of guidelines for terminologies in the Indian context that can be used in the NCERT book. Here, our task is cut out for us, where we have to ensure that if we suggest any changes in the content or the curriculum itself in the language of the books, it has to be sustainable. And for it to be sustainable against all the multiple revisions that these books go through every couple of years, we need a standard operating protocol. We need a set of guiding documents, a set of guiding principles for the authors, for the illustrators, to make sure that whatever changes we propose are consistent. And there is a certain consistency in the way disability is discussed in these books going forward, not just now, but going forward as well. And thirdly, because NCRT and the curriculum has really undergone lots of changes when I was in school, now there's a lot of audiovisual content available as well. There are YouTube videos that are uploaded every day at noon, which can be accessed through a QR code in each of the chapters. The idea is to prepare 5 to 7 scripts where a person with disability, persons with various disabilities are central figures. And the idea is to give these scripts to the relevant departments so that they can shoot videos and put it up as supplementary material alongside these books. In this journey, we have also identified certain enablers and barriers, and I hope that this will be helpful for those who might want to tap into other curricula as well. One of the biggest enabler has been intent. I have to say that the people we spoke to and interacted with at the NCRT were very receptive of what we were trying to say and were very hands-on in their approach, and are very keen to take this forward. Community mobilization, I believe, has been the strongest asset that the disabled community has in our country. Every time I've asked for support, every time I've called people for these in-person workshops, they have showed up, they have contributed, they have given 3 to 4 hours at a time, which was a huge enabler for us. And existing inclusion of disability concepts in the NCRT curriculum already has been very helpful for us because we were not working from scratch. We had something to build upon. And we had many, many entry points. Because the learning pedagogy has undergone so many changes in the last decade or so, learning is no longer restricted only to a pen and paper or examination methods. Learning is a lot more fluid and dynamic. There are activities, holiday homeworks, there are these audiovisual uh, content, there's field work, there's just a lot that these books offer. So we have multiple entry points. We are not restricted to only the main chapter or the main content. There's a lot that we can do. We have faced some barriers also. First of all, our sustainability issues. How do we ensure that any change that we propose is not going to be, is not going to fall through the cracks in the next round of edits? Heterogeneity of disability, something that was also being discussed in a previous panel, has been an issue that we have run into. Because while we want to make the point that disability is extremely heterogeneous and that it's a dynamic reality, there isn't a particular kind of experience. We are also running into the issue that the scope of the school curriculum is just vast. We are not working with disability studies curriculum, we are working with school curriculum. So there's gender, sexuality, caste, religious identities, our histories, civics. It's just a lot. So of course, we won't be able to achieve everything, is something that we are very cognizant of, which is because, and one thing that somebody said to us is that if we just include every disability, how do we include every caste in our country? And that's a very real and valid question from a very practical standpoint. So that's also a barrier that we run into, but we are also trying to work around it. And the last thing I would say, time constraints, of course. It's a limited, the project is restricted. It's a 6-month long thing, beyond which we'll have to ensure sustainability. And the last important issue is that of last mile implementation. A lot of these material that are included in the books do not necessarily translate into them actually being included in the schools, in the classrooms, because there is very little control or oversight over teachers who are actually taking these books into the classroom. So that is a very real challenge that we foresee in making sure that this is sustainable and also coherent across the country. What we have learned in our journey, and again, I'm hoping that this will be helpful for my colleagues and peers who will come after us to work with other curricula, is that our approach of reviewing the curriculum first and then inviting community members and stakeholders as well as relevant authorities has shown promise. I am a researcher and I've always struggled with research findings not often translating into actual advocacy tools or something actionable. But this approach, where we have dedicated some amount of time to actual community consultations and inviting the relevant stakeholders who can help us make those changes, has been helpful for us and has shown promise. So I'm hoping that that might be helpful for others also. We have also realized that disability justice needs to be included in the actual design of the curriculum, in the sense that if you were to remember any school book that you studied, there would be a chapter and then there would be questions and reflections and activities, and that pattern has continued even now. What we have realized is that we need to have a two-pronged approach where we add the most important, most necessary material directly into the chapters, into the main content, and we provide some activities that enable critical thinking, questioning, and things like accessibility and inaccessibility in after the main material, after the main content, to ensure a richer discussion is happening. Overall, I would say that this endeavor has been our contribution to making NEP, certain provisions under the NEP, a reality, because we want to ensure that disability justice is ingrained in the curriculum so that mainstreaming of learners with disabilities is possible, not only from an infrastructural accessibility point of view, but also
Thank you. Thank you,
ensuring
Ayushmita. Thank you.
mitigation, etc.
Praveen Amasta here, Ayushmita. Thank you for your insightful talk. Please share whatever you can share the details with the organizers to be distributed to the district court judges and authorities who are participating in this discussion. And so next speaker, I think we have one more speaker, and I would request that it has to be very short and crisp. Yeah, thank you very much. Thank you.
Yeah. Thanks. Yeah. No. Yes, that's right. Is this working? Thank you so much. Yeah. All right. Good evening, everyone. Thank you to the organizers, the Office of the SCPD Goa, the Goa State Legal Services Authority, the DPWD, and the Goa High Court Bar Association. And of course, big thanks to the lovely folks at Mission Accessibility for curating this workshop and inviting me to participate. It's an honor to be here and learn so much. I'm Tanvi, and I'm a part of the Billion Readers Initiative, formerly known as the Same Language Subtitling or SLS project that was born out of IIM Ahmedabad in 1996. Billion Readers is currently a system change initiative and has the goal of strengthening media access, national literacy, and Indian language learning. It is led by Professor Brij Kothari and is affiliated with IIT Delhi School of Public Policy. We've heard some important discourses on various aspects of accessibility for persons with disabilities, and I'm here to talk about how India can make electronic media, specifically movies, television shows, or digital content, accessible for persons with disabilities and inclusive for all. I'll start with a question very quickly for reflection for you all. How many of you remember the very first movie that you watched? Was it in a cinema or at home on TV or on an OTT platform? The first movie that I remember watching was the animated English movie called The Lion King, and it transported me to this whole other world in the African savannah. Despite seeming otherworldly, it is a story that is deeply personal and relatable to all of us. It's about the anxieties of growing up, about overcoming difficult adversity and grappling with one's identity and sense of belonging. Movies, television, and digital content reach out to tug at our heartstrings across the emotional spectrum. It has the power to shape how we see ourselves, how we belong, and how we engage with the world. That feeling and access to that feeling is an inalienable human right. And today, our challenge as a society is to ensure that in reality and practice, this right is accessible to every citizen, whatever their abilities, and to persons with disabilities, surely. I'm talking about making entertainment in India born accessible and accessible to all. One of the simple ways that we can turn this vision into a reality at scale is by incorporating accessibility features like audio description, Indian Sign Language, and same language captioning into content at quality at the time of creation, rather than as an afterthought, as part of its digital content package. These features, if embedded at source, should also be mandated to travel across distribution channels along with the content, so that further downstream, either on a OTT platform or on any device, users can, based on their needs or preferences, select the desired accessibility features. There are many, many benefits of media accessibility. Features like captions, audio descriptions, and Indian Sign Language, they're not just about compliance, they're about connection. For viewers who are deaf and hard of hearing, Indian Sign Language or captions can breathe meaning into the content. For people with blindness or low vision, audio descriptions open up scenes and emotions that are oft buried in the visuals. And when all accessibility features are embedded in the original content, as I mentioned earlier, a user can toggle which feature they'd like to use on their device or on the platform directly. Today, these technologies are growing and evolving, and with the right kind of mindset, dialogue, and action, as many of the speakers before me have already mentioned, these will only improve with time. And accessibility features can grow beyond these to be accommodating of many, many disabilities across the spectrum. Another benefit is that this approach also connects us globally. When content carries captions, ISL, and audio description right from the source, it doesn't only reach Indians at home, it reaches our diaspora communities abroad, including persons with disabilities abroad, and even new audiences who want to experience Indian stories and languages authentically. In one stroke, accessibility can strengthen inclusion, literacy, language, and cultural reach. There can also be other remarkable curb cut effects, where there are other beneficiaries too when we design for persons with disabilities and make content universally accessible. For example, when same language captioning appears across all broadcast content, it serves a segment of the deaf and hard of hearing community, but it can also turn viewers into readers. Millions of people who have never quite learned to read confidently could strengthen that skill just by watching their favorite programs with captions on. And when we do this in Indian languages and not just in English, it becomes even more powerful. Television and digital content then double up as everyday language teachers in addition to making the media accessible for persons with who are deaf and hard of hearing. I'll just take a step back to quickly talk about the legal and policy framework. Our lawmakers have already laid the groundwork for this, and advocacy efforts from groups like Mission Accessibility have strengthened the momentum. Our judiciary and the grievance redressal mechanism of the CCPD as well has been incredibly proactive. The Rajiv Raturi case in the Supreme Court, the landmark case from last November, enshrined accessibility as a fundamental right and as being non-negotiable. The RPWD Act, Section 42, states that the government must ensure that all content, regardless of form, print, audio, or digital, should be available in accessible formats, and it calls for the accessibility features that I mentioned as well. Building on these mandates, the MIB's 2019 TV guidelines, the 2024 film guidelines, and CBFC certification rules, and more recently, from just a few days ago, the draft OTT guidelines talk about making new content born accessible, with captions, audio description, and ISL being added right from the beginning. This is a major and welcome step towards truly inclusive storytelling. There are challenges, of course. We have vast amounts of new and old content across platforms that are inaccessible. Access to information for audiences regarding which films in theaters or shows on TV have what kind of accessibility features is missing. Quality standards and terminologies often vary across platforms, and of course, goes without saying, physical and virtual built environments needs to be accessible as well. We need policy to be dynamic, capable of evolving. We need to encourage more collaboration and problem solving that brings together the various relevant ministries, content creating and distributing industries, persons with disabilities, access feature technology experts, together in the same room to brainstorm in real time and plan for raising awareness about the very existence of these features sometimes and how they can benefit people. A culture of self-reporting and accountability must be created as well. Encouraging the industry to welcome third-party quality accessibility features, if provided and embedded into their content, is also another way to close the supply gap. Too often for the industry, accessibility becomes a box to check rather than an ethos that shapes design. So we need to change that mindset. Again, I reiterate that what many speakers before me have said. It's heartening to see that the current accessibility standards that are passed and also in draft form do allow for that dynamism and coordination among stakeholders, and we must ensure that what's on paper is put into practice effectively. So I'll just sort of, in the interest of time, just speed up. Our team at Billion Readers has put together more recommendations in a white paper that we've recently published online on our website. I do have some physical copies too. Please do reach out in case you'd like to delve deeper. We'd love your inputs, and we are proud to be allies for this important work. So just in conclusion, let's remember that this is not just a technical or legal journey, it's a cultural one. When our movies, shows, and songs become accessible, we create spaces of hope, of learning, of inspiration, and joy for everyone. India is already leading the way, thanks to the tireless work by Mission Accessibility, the progressive steps taken by the government, a proactive and progressive judiciary and grievance redressal mechanism. Let's push further to make accessible media the default rather than the exception, so that every story told in this country truly belongs to all who wish to hear, see, or read it. Thank you for your kind attention, and thank you so much to the speakers before me for your leadership. Thank you.
Tanvi Mohandas, thank you very much for your insight on accessibility, particularly entertainment contents. And yes, Akshat Baldava versus Yashraj films, Rahul ji has done already. So, vote of thanks. Thank you.
To conclude this afternoon, I now invite Honorable D.P. Satwalekar, Registrar Admin of the High Court of Bombay at Goa, to deliver the vote of thanks.
Good evening, everyone. Respected dignitaries, I assure that I will not take more than 2 minutes. It is both a privilege and an honor to present the vote of thanks at the conclusion of this insightful and impactful workshop on legal rights and empowerment of persons with disabilities, conducted as a part of the dynamic and inclusive Purple Fest in the state of Goa. This workshop has been a powerful convergence of knowledge, commitment, and action towards the strengthening the rights and dignity of persons with disabilities. First and foremost, I wish to express my sincere gratitude to our chief guest, Honorable Justice Shri Abhay S. Oak, former judge of the Supreme Court of India, for dedicating his valuable time to attend this program and for sharing his insights with us. I also extend my thanks to Honorable Srimati Justice Bharati S. Dangre, Senior Judge, High Court of Bombay at Goa, for providing necessary permissions and guidance. My appreciation also goes to Honorable Shri Justice Menezes, the Honorable Judge of the High Court of Bombay at Goa and the Chairman of Goa State Legal Services Authority, for his comprehensive support and directions. We are grateful to Shri S. Govindaraj, Chief Commissioner for Persons with Disabilities, Government of India, for honoring us with his presence and guidance. I would also like to thank Shri Guru Prasad Pavaskar, State Commissioner for Persons with Disabilities, Goa, for his vision and purposeful leadership in spearheading this initiative. Additionally, we appreciate Senior Advocate Mr. Koil Pereira and the High Court of Bar Association for their invaluable support and cooperation. I also extend thanks to Advocate Mr. Rahul Bajaj and Amar Jain, co-founders of Mission Accessibility, as well as Mr. Turab Chimtanwala and Ms. Sara for their active involvement and informative contribution to this occasion. Our distinguished panelists and speakers, Senior Advocate Mr. S.K. Rungta, Advocate Kanchan Pamnani, Shri Praveen Ambastha, Deputy Commissioner, Persons for Disabilities, Government of India, Ayushmati Samar, Tanvi Mohandas, Advocate Anchal Bhateja, Advocate Amit Birze, deserve recognition for enlightening us with their expertise, case studies, and practical perspectives. Your input has been both instructional and empowering. A special note of appreciation is due to the Department of Persons with Disabilities, Government of Goa, for playing an essential role in organizing this workshop and for their ongoing commitment to fostering a barrier-free and inclusive society. To all participants, including persons with disabilities, caregivers, legal professionals, social workers, press, media, thank you for your thoughtful engagement and for attending the program. Lastly, I offer my heartfelt thanks to entire support staff volunteers, and technical team whose dedication behind the scenes ensured the seamless execution of this event. Let us carry forward these insights, commitments, and correction established here into our future work. May this workshop serve not only as a conclusion, but as a foundation for enhanced collaboration, deeper understanding, and collective empowerment for the persons with disabilities. Once again, thank you all.
As we close, may the conversations and collaborations initiated here today continue to drive change beyond these walls. Thank you once again for your presence and participation. Wishing you all a pleasant evening ahead. Thank you. We also have a few refreshments that will be served at the pre-conference hall. Those who have not received any may please proceed to serve themselves for their refreshments. Thank you.